Mr. Faust. Well, uh, what may or may not be shown. I will try to not spoil because I know you're going to speed run through this. But everything the state said they were going to do in opening statements, and everything the defense thought the state would tell them in the trial during their opening statements, everything did not come true.
My shock. A
Yeah,
Georgia trial in which things don't come true?
yeah, isn't it amazing? And I think we are. Yep, I'm live at my channel. Hello, folks. This is Verdict Watch. I hijacked Mo's speedrun.
Yeah.
So we are going to watch the trial while waiting for verdict. And I have. So Mo is playing this. I have shared my screen so we can watch live on our little downstairs screen
Yes.
if anything happens.
Yes.
If anything happens. So hello, folks, and welcome to
I
Verdict
don't like
Watch.
I don't like this judge not wearing robes. She just reminds me of a mega Karen, like head of HR.
Mm. Yeah, and so something also I don't know if it's not really spoiler, but at the point of opening statement, the defense had 12, I believe, 12 or 13 outstanding motions that she had not responded to.
Oh, so
Or,
she is a judge goal.
or a Judge Bev or a Judge Gull. I mean, there's somewhere in between there because with Judge Gull, she wouldn't let us watch. Now, this judge seems to believe, oh, I'm the best that happened since unsliced bread. I'm going to show the world. She doesn't have this. She actually believes she's doing okay. And Judge Gull knew absolutely that what she was about to do, she had to conceal.
Yeah.
Oh, and by the way, I asked over at X a couple of hours ago. Let's see here. Where is it? Where is it? If you can share my screen.
Oh, sure.
Do I need a 10-pound jar of pickled everything?
I don't think so. I mean, that's a lot of hoagies.
Of
And
course I
thank you
do.
so much, MLS. I mean, you never run out.
Of course I need a 10-pound jar of pickled everything.
Who
I
doesn't?
think it's more than 10 pounds because it is, yeah, or maybe exactly, it's like 4,900 grams, 4.9 kilos. It's maybe, it is exactly 10 pounds of pickled everything. Thank you, Dave. Because
Wait,
now I
you
can.
have
What?
is that lasagna flavored Pringles? What's on top of that? Because I can read lasagna or something that's looks
No,
like
that's
lasagna.
that is lasagna mix in a jar. As in the thing you pour over the lasagna
Oh, so
pasta.
sauce. Okay.
Yeah, yeah.
Okay. Who's paying $80 for the 10 pounds of
No, uh, that's 80 Swedish krona, which is about $7.50 for 10 pounds of pickled everything.
I mean, it's a bargain, but I still don't know what I'd use it for.
But the store I'm in is called Lidl. It's one of these stores. It is a mini Walmart. You can buy
Okay.
clothes, tools, food. Uh, yeah, more like and they have the Christmas theme, and they have
Oh,
spring,
yeah.
and stuff like that, which they sell. And sometimes things like this show up as limited in the store right now, and probably because it's a surplus from somewhere else.
Yes.
Now I have this, for instance, if I'm only want to fry up a few hot dogs, yeah, and a big of pickled everything on the side.
I
Yes,
mean, you wouldn't
Yakety,
run
but
out.
I suppose. See, what's the best before date here? I have to eat this before June 15th, 2027. I think I'm good.
You know, we're gonna know when it's getting close to the expiration date, because the wheel of regrets is gonna be pickled everything on every other slot.
Oh, yes. A spoon of pickled everything. Now, so I haven't opened it yet, but at some point after, I haven't tried it. I want my pickles quite, what do you call it? Zesty. And
You're supposed to be. The whole thing is to preserve them. I don't think they get better with age. I don't know. I've never heard like this is a 20-year aged pickle and this is a 50-year. Would you like our? I'm not a
yeah,
pickleologist.
but at some point I will throw down a habanero or something in it to make it a little bit more kick to it.
Good idea. That's it. We need a Runkle and Nick pickle off.
Yeah. I mean, me and Ian beside each other on a table, and we have this jar and either a spoon or a fork. The zest is called bacteria buildup. No, it's called taste.
Botulism, the season that keeps on giving.
Oh. Yeah, so I did buy a 10-pound jar of pickled everything.
Well, I bought the Aldi wine advent calendar, so I guess I can be tempted too.
Oh. I mean, folks, this trial is horrific in the bad. I mean, what happened to Tara Baker is absolutely horrific. And what made it worse was, besides that, the DNA didn't show up until 20 years later because it was just trace amounts of it, of everyone, because there were no hits on the DNA test back in 2001. And so, yeah. So every piece of, what would you call it, DNA in here, the
Yeah.
trace amounts, nothing was known back then about the DNA. Not Mr. Melton's, which, well, Mo is going to find out when she sees him testify sooner or later.
Well, I guess that's the other thing. So you're trying to get me to believe that this random guy in the middle of the morning decided to rob a house that typically has roommates and stuff. He just happened to stumble in
At the
and,
exact moment, the day. Yeah, according to the state, that is what they claim. And also, something you will find out later in the trial when they have Tara's best friend and roommate on the stand on cross-examination. She said back in 2001 to the investigators, it's almost as if whoever did this knew she was home alone, because they were always together.
Well, That's the other
Except,
thing, and then this random person decides to take up time to clean up the thing and
mm,
then start a fire in the oddest way I have ever heard of a fire being started.
yeah, that is what they claim from the evidence back in 2001, and they never re-examined that evidence to see with modern technology if they could reach another conclusion.
Interesting.
Yeah, and Mr. Melton, he made interviews with a podcaster a
Of
few
course
years
he
ago.
did.
Yeah, I haven't actually watched it.
Yeah, those will be interesting, but you would think, again, if this has been
Mm,
hanging over your head like a cloud,
yeah,
you
and
would y
mm,
yeah, so a lot of this hasn't started adding up to me, and it really again, the DNA would be part of it, but as a juror, I'm wanting to know, okay, well, once you got the DNA, how did you link him? Because you
mm,
wouldn't think that, a guy who has kind of
mm,
a long rap sheet for kind of minor crimes would intersect with this woman. So how did your DNA get here? Were there crimes that linked him? Were there a series of robberies?
mm.
Nothing else. It just said, "We found the DNA and we charged him with murder," and I don't like that it didn't seem like there were anything else that was tested once they found the DNA.
I It's hard for, I mean, you're going to see it sooner or later, and it's hard because I don't think I can explain it good enough. And
Well, that's the other part of why we picked this case to look at, was because everyone was losing their mind, and I was like, "Oh, we have to look at this trial, even though
yeah,
we're probably gonna miss
mm,
the verdict watch and or
mm,
at
mhm,
least
mhm,
miss, you
yeah.
know."
Now, there's a lot of breaks and a lot of pauses and stuff like that. So even though it seems like 8-hour days, no.
That's
The
also
one
what I've
hour
heard.
lunch that is 90 minutes, the 10-minute breaks that are 20 minutes, and then they are up on the sidebars, and there are objections. Well, you saw one.
Yeah.
Yeah. And the motions for mistrial,
Yeah,
plural.
it just seems, like, odd if you want me to buy that this was a burglary and you luckily into a house that has 3 different people, you would steal from 3 different people, you wouldn't just steal from 1.
Yeah, and at the time, Tara Baker had diamond earrings. They were still on her.
Yeah, so the whole burglary thing just doesn't make sense to
Mm.
me
Now,
at
no,
all.
yeah, but they have to invent a way to get somebody in there, and the only way is
Yeah.
to say, well, they had to do the breaking and entering and burglary, but there is literally zero evidence except what the state claims is he, as in Mr. Faust, got in there through some sort of coercion or violence.
And yes, they are deliberating, they just started about 17 minutes ago.
Yeah.
Alrighty, let's get back into the opening.
But you were here from Mr. Jeffries. That is the state's evidence. Not a single shred of evidence will place Mr. Faust in Miss Baker's home. And the state has told you themselves, they've admitted it. We don't know how he got into the house. The evidence will show that Chris Melton admitted that Miss Baker had a key to his house. You have to decide if it's reasonable that Miss Baker.
I'm going to sustain that.
Yes, ma'am. But the state will rely on Cedric Jeffries, who, when he walks in this courtroom, he is serving a federal sentence right now, 104 months. And this isn't the first case Mr. Jeffries has testified on. Now, he may admit it, he may not admit it. But Mr. Jeffries at this time has testified on 2 other cases. He is a witness that gets in on cases and comes and testifies for the state.
That witness was never called.
So
The
that's important.
prison
You're going to
snitch.
hear the interview of Mr. Jeffries, or he may admit it, so it may not get into the interview. But you're going to hear that Mr. Jeffries, one of the things he says is that I've never heard of this case before. Okay, and the state brought it to your attention that Mr. Faust stated that, in his interview, he made statements about Ms. Baker. We're going to get into those statements. But before I get into those statements, I want to talk to you about sketches you'll see. The state is going to present sketches to you. Okay? And what these sketches are of African-American men walking through Deer Park neighborhood, right? Police does a canvass after they found out about Ms. Baker's death. And during this canvass, they're talking to neighbors saying, hey, what did you see? The person that stays directly across the street, hey, Your Honor.
About 17 minutes.
Yeah, they came back 12:30 today. Now they did technically start on Friday, but that more or less they went in, probably just shows a jury foreman, and then went home.
The house with blue tarps here at Baker's house. The house across the street, I believe that is Mr. Matthew Owens, Mr. Jay Anderson. I may be mistaken. I think Matthew Owens definitely stays there. Mr. Jay Anderson and another individual. And when police come and talk to them, what they're going to tell you is that we see a guy in a bright orange shirt. And as you know, in UGA country, you don't wear orange if you're trying to be here. But we see a guy in a bright orange shirt. He's either wearing khakis or jeans, and he was walking in front of, down the street in front of Miss Baker's house. And the officer asked, can you describe him? He says, yeah, he has like small afro hair, black male, orange shirt, jeans. They said, well, how's he walking? He said, he's just walking regular. Just walking. But he says, I leave to go away. I walk away from the window for a second. He said it's maybe 5 or 10 seconds he walks away from the window. And he says, when I come back, that person is gone. I don't see him anymore. He said, there's no way they could have made it to the end of the street because he says, I can see both sides of the street. He said the person had to cut through the houses. And then you will hear from Miss Tiffany Riker. And that individual, I think it's Jay Anderson, but the evidence will show the proper name. He doesn't do a sketch, just to be clear. But you will hear from Miss Tiffany Anderson, Tiffany Riker, who stays right here, this house here. She's going to say when she's coming out of her house to get in her car, she also sees a black guy. And she gives the same description. Wearing an orange shirt, blue jeans, khakis, she's walking down the street. And that's the thing I said. She backed up. She said, you stop. You get out of my car. Now, what you'll learn in this case is on the other side of your car.
Okay, did anyone stop and ask these witnesses if they were white, what they mean by a small afro? Because with the picture that they showed of Mr. Faust in the beginning of the defense's opening statement, I would call that a kind of grown-out fade. But what do they perceive as an afro or a small one? Because it can be very different culturally.
Yeah, and exactly, and it may or may not. I mean, we are talking about a neighbor across the road who was alerted by his roommate, hey, there's something going on. And that something that was going on was a black man walking by.
To be fair, we get a lot of those in my very rural Indiana neighborhood. Like, y'all, Amazon is a thing. The amount of neighborhoods we get on the old biddy, neighborhood thing, like, I don't know if you guys are aware, but there is a suspicious vehicle with someone with a darker complexion. And I'm like, y'all, it's called Amazon delivery.
Yeah.
They're going
Does
to
it also
houses.
say DHL on the side? I mean, we have those things over here too.
Yeah.
Hey, did somebody see that van? Well, and I just more or less screamed back. No. Somebody saw there's a new vehicle. I mean, it's wow. We haven't seen that vehicle before. And I just waited an hour. It's mine.
I'd have never admitted to it.
I mean, this is like when I changed from my prior car to the Saab, and apparently among all the farms out here, that was an event. What's this new car? Is it suspicious?
Yeah, it didn't it from what I'm getting from the state, they didn't do a very good job investigating. They found this DNA, and then they made the case fit the DNA, not
Yeah.
the evidence fit the case or anything else.
Yeah. When we get to those witnesses, you're going to be so pissed off.
Oh, I probably will.
There's another photo you'll see during this trial. There's a Walmart. There's the Walmart on Lexington Road. So people travel from this neighborhood up here at the top through your park and around here. I think somewhere around here you can cut through and go to the Walmart on Lexington Road. Okay. And Chris Melton will tell us that African American foot traffic was coming. Tiffany Wright would tell us that she didn't think anything of it because African American foot traffic is coming. She thought the guy was walking to Walmart. But when police get this information, despite Ms. Kashona Armstrong saying we saw a gentleman running through my backyard, police say, okay, let's do a sketch of this person. So you're going to see a sketch of a guy who may not even know his pictures involved in this case. But they're going to show those sketches. But they're also going to show a sketch from a young lady. She was the wife of the tow truck driver. Okay? And the state may change it, I'm about to say it, but the state may try to make this one person. Okay? But it's two different people. She says, hey, I see a guy. I was out with my husband. We're picking up a car. I saw a guy walking down the street. She says this guy has a heavy set face. He's kind of heavier looking. I can't really tell his body because of the jacket he has on. She says it's a bright jacket, but she says it's long sleeve, which is different from the individual that Ms. Riker and the individuals that stay across the street from Ms. Baker. Different from the individual they saw. They say, well, how was he acting? She says, well, he was just walking down the street. She said, I actually watched him in my mirror the entire time he walked, and he was just walking. They say, well, did he have on a hat? No hood, just a jacket, just walking down the street. The state is going to present those pictures to you as Mr. Faust. They're going to say, hey, it's a black guy in the neighborhood. This is Mr. Faust. But again, the only evidence they can present
it's literally what they claim. And they have two sketches where they put beside the picture of Mr. Faust at the time. I'm the whitest guy on the planet Earth, and I saw differences. But according to the state...
Well, let's be very real on a very objective. The picture that they showed of Mr. Faust, he has a very symmetrical face. So when the defense admitted he was a bit of a playboy, I wasn't too shocked. I mean, that would be a face that you would say, "Oh, that's an attractive person," because symmetrically, and face wise, it's a very attractive face. I wouldn't ever say heavy set. Heavy facial features. That wouldn't be what I would say at all to that face. But there we go. I mean, sure, the same color palette, same people.
I mean, the prosecution is living testimony to the joking prompt that white people can't tell black people apart.
Yes, but the other prosecutor is either Indian, Bangladeshi, or Pakistani. So
he's Indian.
Oh, okay. Well, I didn't know because you could look Indian but be Bangladeshi or Pakistani also, and still look. I'm not getting canceled this year, at least for that. I want to do something more epic. I'm going to be canceled.
Right? But those are the sketches they're going to present to you. One of the sketches, and it's up to you to decide, does not fit the description given at all.
No.
And you will hear evidence, you will see those sketches, you will hear the information given by those witnesses about what the person looks like. But the photo that I showed you, Mr. Faust with the hair, they're going to say, hey, this is Mr. Faust with his hair, and these are the sketches. Ask questions about the sketches. Look at the sketches. Listen to the information that the state gives you about the sketches. And just make sure I'm clear, the person that was reported walking in front of Ms. Baker's house, our position would be this is the same person that Ms. Riker saw coming down this way, just for clarity. Lastly, you are going to hear Mr. Faust's interview. you're going to hear what Mr. Faust himself said about this case. You will learn, contrary to what the state has told you, that Mr. Faust was told when he was arrested, we're arresting you for murder and aggravated sodomy. They hadn't asked him anything. That's what you're here for. Murder and aggravated sodomy. Mr. Faust is confused. He talks to him. He chooses to talk to him way this right because, of course, he's trying to figure out what the heck is going on. While they were talking to Mr. Faust, they didn't tell him whose murder. You will hear Elizabeth Bigham and Jeremy Howell ask Mr. Faust, did you hear about a cold case from 23 years ago? And that's how they ask him. Did you hear about a cold case from 23 years ago? Mr. Faust tells him, I vaguely remember, and this is a paraphrase, not a quote, but I vaguely remember it. I think I saw something in the paper about him. You will learn. Jeremy Howell nor Elizabeth Bigham show Mr. Faust a photo of Ms. Baker. Jeremy Howell nor Elizabeth Bigham tell Mr. Faust Ms. Baker's name. They don't say, Tara Baker case. They just say, hey, you heard about the cold case from 23 years ago. They don't even give Mr. Faust the opportunity to explain the DNA because what they tell him, and this is very important stuff, they tell him, why is your DNA found in that house? Mr. Faust said, house? I've never been to a house in Deer Park. My DNA in the house? Your DNA is in the house. And just as much as I'm here to exonerate, I am here to hunt. But the truth is, as I've told you, the evidence will show there is not a shred of evidence putting Mr. Faust in the house. They didn't have that evidence. They misled Mr. Faust, and of course, here he's charged with murder and aggravated sodomy. He's probably freaking out, and he says, I don't know anything about the house. I don't know that woman. But again, they never gave him an opportunity to confirm who they were talking about. No name, no photo, just the cold case from 23 years ago in Deer Park that your DNA was found in the house. What you're learning in this case, one person lied to police over and over and over and over and over again. One person simply said, I've never been to a house in Deer Park, whatever you're talking about, I don't know. And the person that's in that chair is Mr. Faust. Now, Miss Baker, as we all know, is a very beautiful woman. They showed us a photo, or the photo that Mr. Faust was aware of. The photo that you all saw was not a photo that was shown to Mr. Faust. I do predict that the state, they may change this, I predict that the state is going to attempt to play for you an audio version of Mr. Faust's interview. Because the video version will show that Mr. Faust was given no information other than that he was charged with murder and aggravated sodomy for a cold case that occurred 23 years ago. On the video, you will see no pictures shown to him, as I mentioned. The state's evidence may get you emotionally riled up, but those are not answers. I think this is significant for everybody to know. So in 2001, Mr. Melton is told, as I told you before, that Ms. Baker was sexually assaulted. I may not say the sexual assault, but he knew. They told him in 2001, and that's when he came back with, I saw her 6 days before she passed away. When he was meeting with Elizabeth Bigham and Jeremy Howell, they told him, hey, we found another person's DNA in her body. And Mr. Melton's response was telling. Mr. Melton himself said, sounds like she was with someone else. Objection again. This is evidence in the case.
Ladies and gentlemen, I'm going to ask you to go into the jury room for one more moment. Please don't discuss the case.
Yeah, without the robes, she just looks like my high school teacher that's mad at me for not being politically correct again.
Your Honor, Mr. Yalamanchili and I had talked in anticipation of us getting to this point over the weekend. Since I had made opening statement,
You pull that microphone towards you. Thank you.
that I would object since I had made the opening statement, but since Mr. Yalamanchili had made the 412 arguments in the past that he would handle.
All right, thank you. Go ahead, sir.
Your Honor, as the court's aware, as the state's aware, if Mr. Cruz wasn't aware before we started all the pretrial motions in this case, he ought to be aware now. Making reference, whether it's a statement made by some other witness, whether it's elicited direct examination, cross-examination, or any other method to a relationship between Miss Baker and anyone else that was not noticed by the defense as a 412 act
This is
prohibited
the
by 24
grape shield
412.
law they are talking about. And in order, you cannot bring up a grape victim's schmectual history.
I
As a
can
defense.
understand. Well, I can
Yeah.
understand that it was maybe used in questionable ways, but I think there has to be. Why do we make statutes when common sense could be used?
Yeah, but this is a specific law in Arizona. A specific, not just statute. It is a law that, regardless, which also in this court's interpretation means that the defense can't even suggest that it was consensual.
Not sure how much clearer the statutory language could be. Not sure how much clearer the court could possibly have been in its instructions. But whether it's Mr. Cruz making reference to a statement that some witness made during an interview with law enforcement, or whether it's Mr. Cruz eliciting the testimony on direct examination or cross-examination, it is all prohibited by the rule, which Mr. Cruz has violated now for the second time in his opening statement. It does not matter. It does not matter one bit whether or not Chris Melton said that in an interview to law enforcement for the analysis of whether or not it is admissible and the methods that must be adhered to if the defense intends to admit it in any way, shape, or form, Judge. And so this is the second time before we've called the first witness to the witness stand that Mr. Cruz has violated 412, and what seems at this point to be an intentional pattern to try to work his way around the laws and rules of the state of Georgia as it relates to admissible evidence in cases involving allegations of rape and aggravated sodomy, Your Honor. So again, at this point, I don't know what the remedy is that the court wants to enact. But obviously telling Mr. Cruz not to do it
In
isn't
this
effective
case,
because he's
they are
not
using this both as a sword and a shield. They use her history by saying, Faust DNA inside her, that's grape. Melton's DNA inside of her, that was consensual. And the reason is, well, he was her boyfriend. It's supposed to be there. As if nowhere in history a boyfriend has ever done bad things to their girlfriend.
Yeah, it would just seem that if it's a totally random person, like the state wants me to believe, then that random person, would they have thought to clean up all the blood? Would they have thought to start a fire? Would they have thought to lock both of the doors with the deadbolt?
Yeah. How did, if the key is still on her keychain, how did the door got locked?
Yeah, and if you're the state and you've had 25 years to build a case, we can't tell you how he got in there. We can't tell you this. You should be able to tell me something other than DNA was found.
And we went through this on Friday. The state claims Chris and Tara Saturday night, Sunday morning. This was Friday, 6 days later.
Yeah, there's just no way. And then from 5 days later, when whoever decided to go in the back door, there was gravity and drip it. And
and everything. And here, remember, these are trace amounts. You would imagine if the DNA deposited at that point in time, there would be more than trace amounts on either of them.
yeah.
Of either of them. And when they got to the DNA testimony, the DNA match for Faust was in the billions, which is a lot, but the DNA match to Chris was in the octo something. So there was a larger presence of Milton's DNA than of Faust's DNA.
Yeah.
And it's so stupid.
And he's not following the court's orders.
Bruce.
But here's the thing. Her
Here's-
sexual history is the entirety of the state's case. But they are, through this grape shield law, precluding the defense from arguing. Because the moment they say, Chris Melton, that was consensual, this was grape, they are actively saying, we are bringing in her sexual history in this. They
Yeah.
already opened the door. But not according to
Yeah.
this court.
Well, especially if, again, the whole case is based on consent. How can you, as an outside party who is not Tara, say whether she consented at all to either of them?
Yeah.
DNA doesn't tell you, yes, I'm consensual DNA, and then the, bad guy DNA wears little, like, robber
Yeah.
outfits.
Yeah, but according to the lead detective, Chris was her boyfriend. It's supposed to be there.
Okay.
Absolutely. I'm actually blown away and in shock that the state is taking this statement to be a 412 argument. Our theory of this case is that Chris Melton committed this crime. Chris Melton stated that when he's confronted with DNA that he already knew was present, that she was with someone else had, it has nothing to do with us trying to get around 412. That statement is for the sole purpose of showing his consciousness of guilt. He knew this information in 2001. He showed the exact same information in 2024. And his response isn't, oh, my girlfriend, I can't believe this happened, you guys better ponder. His response is just simply to say, oh, well, let's do it. He she was with somebody else. There is no evidence that I intend to present that Chris Melton knows about Ms. Baker's sexual history. There's nothing I can intimate that Ms. Baker knows, that Mr. Melton knows about Ms. Baker's sexual history. The purpose of that statement has nothing to do with her character, under 24/12, her sexual character. The purpose of that statement is to show Chris Melton's response. When he's presented with some evidence, he gives a response that's inconsistent with the person that is innocent. So this isn't a 412. I understand the state may not like what I present, but that does not mean I have to preview every single statement I have to them so they can compare their case.
And
This is
especially since the state will call Chris Melton to the stand.
Yeah. And why are we going with all of the degradation and fire injury, are we even really sure about the time of death? Could this have been something that happened?
She had soot particles in her airways.
Oh, okay.
Yeah. So, but we don't know when everything else happened.
Fair point.
So sadly, it seems as Tara, sorry for saying this, hopefully she was unconscious
Yeah.
with just a breath of air left in her.
Yeah.
Because, yeah.
I respect the court. I do anything for this court. I told the court that multiple times. This is not a 412 argument. This is Chris Melton, who knows nothing about his Baker's sexual history, being confronted with a piece of evidence and making a statement that shows consciousness of guilt in our view. This has nothing to do with sex.
As this court has stated multiple times, this is the second time today, multiple times during hearings, that there is a process that must be adhered to in order to get the appropriate permission from the court to introduce statements, evidence that another party objects to. In this particular case, it is a 412 motion. We have talked about this over and over again. What I have said over and over again is that the defense has failed to file a motion under 412. The state did. The defense has failed to file a motion. And I've said many times that if the defense files a 412 motion, even though it's not timely, the court will consider it. There has been no motion filed. Mr. Cruz, you've been made aware many times that you are not to bring in this kind of statement. I mean, I realize I have said several times today that opening and closing arguments of the attorneys and arguments are not evidence. And I'm going to say it again when the jury comes out. But you've been told many times that in order to, I'm talking now, Mr. Cruz, thank you. You have been told many times that in order to present statements like that, ask for the admissibility of evidence like that, you have to file the proper motion. And the court may consider it, even though it's not timely. As I just stated 10 minutes ago, I do find your statements to the jury to be avenues to circumvent 412. And it is not appropriate. I'm finding you in contempt of court. You have had the
Now, listen to this first.
Okay.
opportunity to explain yourself, and I'm finding you $1,000. And you are to present that $1,000 tomorrow morning by 9 a.m. Put it into the registry of the court. And that is my sanction for continuing to not abide by this court's orders. I don't know how many times we're going to have this, but it really can't happen.
Okay. Here is where I believe the judge made a crucial mistake here. Yes, they have not filed a 412 motion because they're not seeking to introduce it under a 412 exception. They are introducing it under the exception of consciousness of guilt, as he explained to her. In order for her to make this judgment, she has to make that analysis. Because this is, as she said, oh, they are just trying to circumvent. Well, of course they are.
Yes, because you've...
If you don't want it, if you don't get it in through the 412 motion, okay, let's try this. Or this. And then the judge still has to make that analysis because there are different sets of rules, court rules, and then she has to weigh them against each other to see which has precedent over each other. And this judge does the same thing about third-party culprits. When the defense brings up other possible acquaintances of her during the time that Milton says they had a relationship. They are not doing it for the truth of the matter. They are doing it to show that the relationship between Chris Milton and Tara Baker was nowhere near as loving as the state makes it out to
couldn't
be.
it also be, to establish that there wasn't a good investigation done at all? I mean, if
as
the
well.
state...
Yeah, that is one of the arguments they used when this is later on, is we are not saying this because we are for the truth of the matter that these guys are either suspects or lovers or anything. No, this is we are asking the investigator this because to show to the jury what a botched investigation it is. But she wouldn't have it. She again said, you're trying to circumvent it. And I'm losing my mind on my streams. Because no, judge, you have to weigh the exceptions against each other and then determine which has precedent over the other. And she did none of it. None of it.
No, I mean, it sounds very much like Bev asking Hank what we should do and then saying, okay, well, Hank said we were going to do this. I think the state said it the best.
Yeah.
Happen again, $1,000 tomorrow morning by 9 o'clock. You may bring the jury up. Thank you.
Yeah, and did you see, back up a few seconds. Back up.
Oh, crap. What did I do now? Oh, as per usual. Just...
Now, this is...
I can't remember if it was...
I wish I could...
I wish I wouldn't have touched them. Oh,
Yep.
Here we go. Right here, I think.
Files a 412 motion, even though it's not timely. You are not today. That opening and closing arguments of the attorneys and arguments are not evidence, and I'm going to say it again.
Forward.
When the jury comes,
Forward.
You do find avenues to circumvent the opportunity tomorrow
Forward,
morning. It
forward,
really can't
forward.
happen again. $1,000 tomorrow morning by 9 o'clock. You may bring the jury up. Thank you.
Look at him. He's staring right into the camera. Just
Yeah.
Yeah. This is his Kodak moment. He's just told you so.
Yeah. But it also, again, part of law is if we can't get it in this way, let's see if case law supports it another way. As a judge, you should understand that there can be multiple ways that you can use a piece of evidence. So it shouldn't be shocking that if you've told a lawyer no, and this is pivotal to his case, yes, Boosh, he was found guilty on all charges, and the verdict came in with about 5 hours approximately.
I got the
Okay, well,
gravy and
Did X crash again?
I don't know.
No, there it is. It was. Or? Yeah, X crashed again.
I had nothing to do with that.
No, me neither. Me neither.
By the attorneys, whether it is in opening statements or closing statements or during arguments, any statements by the attorneys are not to be considered as evidence. Mr. Cruz?
Thank you, Madam. At the end of this case, when you go back home, you're sitting around the dinner table, and someone says to you, "Why did you find Mr. Faust not guilty?" You're going to say, "Well, I was fed a wealth of information. All this information came and it boiled down to one thing. The state couldn't prove that Edrick Faust was the person that killed Tara Baker. The state could not prove or present evidence that Mr. Faust was in Miss Baker's home. All of the hair found on and around Miss Baker's body was Caucasian hair. Mr. Faust is an African-American man. And that's why we voted not guilty. The prosecution in a murder case is required to prove their case beyond and to the exclusion of every reasonable doubt. Not a forced doubt or a speculative doubt, but a reasonable doubt. They have to present a case from you from A to Z. If A is Mr. Faust's DNA and Z is law enforcement's investigation, they never answer the question at G, at H, at I, at J, K. They don't answer the questions about his melon. They don't answer the questions about the hair, even the hair found in her hand. If he did it, why would she have somebody else's hair in her hand? Why would she have non-African-American hair in her hand? If Mr. Faust did it, how did he get in and out of the house unseen? Why didn't anybody see a black male running through the neighborhood? If he did it, why would he take so much time cleaning up her apartment? He doesn't know who stays there. There are 3 bedrooms. If he's a stranger, why would he take that time to clean her apartment? This was a crime opportunity. You all swore to uphold the law, to hold the state to its burden. There is evidence here of reasonable doubt that Mr. Faust did not kill Ms. Baker. And it is not just sprinkled through this case. Reasonable doubt lives in this case. When you all have heard the evidence in this case, we're going to ask you to render a verdict of not guilty. In this nightmare for Mr. Faust, I am asking you individually and as a body to find Mr. Faust not guilty. Thank you.
All right, thank you, counsel, for both parties. Ladies and gentlemen, we started a bit late today. It is certainly late. I am going to give you a lunch break, even though it is certainly late. I'm going to ask that you return here at 4 o'clock. We're going to try to get into
Lunch break? What is this courtroom?
Yeah.
Do we even courtroom in this courtroom? I mean, look at this. Like 90% of it is break.
Yeah. I know.
That's it. If I ever become a lawyer, I'm doing it in Georgia. This courtroom, to be exact. I want banker hours.
Yeah, sorry, folk. I said Arizona first. I meant to say Georgia. My apologies to Georgia and Arizona.
Oh, come. There we go.
Back on the record. State of Georgia versus Edrick Faust, SU 24CR0547. Is the state ready to proceed? Is the defense ready?
Yes, ma'am.
All right, thank you. State may call its first witness.
Freeman?
Could you get David Freeman, please?
Yeah, they're asking about statute of limitation in chat. This is the statute of limitation was there for the grape and because since it's in a connection of another crime, the statute of limitation gets pushed away or pushed back. That is called the Baker Act. So they actually did the law due to the Tara Baker cold case around the time of these podcasts a number of years ago.
Yeah, it just, again, it seems like there was a podcast and then there's a trial. And we've seen this happen several times.
Yeah.
With the Michael Turney case in Arizona, with the Chris Wolfenberger case in Georgia, and now this particular case. And I think people and prosecutors you would think prosecutors would understand that there's some things we cannot get into a court, but they seem pressured to bring these very unstable cases. Yeah,
but here, and this is what makes this judge worse than Judge Bev. She actively tells the attorneys at one point in this trial that since this is a cold case and highly circumstantial, and she then implies that the burden of proof is lower because it's a cold case. When they come to, I want one of these things to be a surprise for Mo, but when they, the slides where the hair and samples are on, when they unpacked them, or I believe day 5 or 6 or whatever's, some of them were cracked. Meaning the samples at some point were mishandled to the point that they cracked.
Yeah.
And it's still admitted into evidence because according to this judge, we have to lower our standards because it's a cold case and this was 25 years ago. Fuck no.
No, I mean, even in the Canero case, there were DNA samples because it happened in 2018 that they couldn't get any readings on. So then in 2024, they reran them again and they found different results. And, they still had Paul pretty much dead to rights, but they went on and tested these and got more results. So no, you don't. If chain of evidence is broken, if things are mishandled, then you can't tell when the contaminant. Why am I the voice of reason?
Yeah. Why are we the voice of reason? Watch us on Fridays and tell us. Have you met us? Especially on Fridays?
We should not be in charge of stuff.
We should not be in the same vicinity of each other because things get weird.
Yes. Are we even going to get to a witness? Oh, yeah.
Yeah,
okay.
We will.
I'm just telling you, when I used to work retail, I avoided this woman. She was going to ask me a question or ask me for my manager.
Yeah.
So I'm going to ask you to raise your right hand, please. Do you swear or affirm that your testimony in the matter pending before the court shall be the truth, the whole truth, and nothing but the truth, so help you God? Okay, you can have a seat. Sir, I'm going to ask you to state your name and spell it for our court reporter, please.
David, D-A-V-I-D, Freeman, F-R-E-E-M-A-N.
Sir, I'm going to ask you, back in 2001, how were you employed?
I was a firefighter at Athens, Clark County.
Okay. Can you tell the jury, please, just a little bit about your firefighting career with Athens, Clark County Fire Department?
I was generally assigned firefighting or driving the truck I did both. When I say firefighting, I mean actually pulling the hose off and, fighting fire.
How long did you do that, sir?
26 years.
Was there a primary station that you worked out of in those 26 years?
I worked in all of them at one time or another. I worked at all. We had 6, then we had 7, then we had, I think they got 8 now, but I worked at all of them at one time or another.
Do you recall where you were working in January of 2001? Which station?
Station 5.
Which one is that?
Whit Davis at Whit Davis Road.
Mr. Freeman, do you recall being dispatched with other Athens-Clarke County police or Athens-Clarke County firefighters to a call at 160 Fawn Drive?
Yes, sir, I do.
Is that address in Athens-Clarke County?
Yes, sir, it is.
Do you recall approximately what time of day that call came out?
Generally, we clean up the station in the morning, check the truck, do household stuff, and it was before lunch. I can't tell you exactly what time.
Okay. Mr. Freeman, if you could please describe what you observed as you approached 160 Fawn Drive.
The call came in, I believe, as a structure fire. Me and another firefighter were on the back of the truck, which means we actually have the nozzle. We pull up to the front of the house, or front of the apartment, and you could see the left side of the apartment. It had broken through. You could see flames. So as a firefighter, you're taught to go in the front and push the fire outside. So I had the nozzle. We went to the front door. I was putting my mask.
Push the fire outside. Maybe that's how they teach. I've never been to fire school, but okay.
Mask on, and I reached up and tried the door, and it was locked. And I believe the lieutenant on the truck is who actually kicked the door in. When he kicked the door in, it was almost like a training fire. You could see smoke had come down about head high, and we're taught to crawl. But that day the smoke wasn't all the way down, so I could see a glow in the right side of the back of the room. Which
I'm going to stop you right there. So just to clarify a little bit, did you go in the front door of the house?
Yes, sir, we did.
And as you enter the front door, where in the house are you situated, if that makes sense?
When I go in the front door?
Yes, sir. Like just kind of generally
The best I can remember, because when we pulled up in the truck, you could see the fire in the left back of the house, and you could see the flames shooting through. So I had in my mind that when we went in, I was going to go to the left. Well, when we kicked the door in, you could see in the right back of the room, you could see red glowing.
And what did you do when you saw that red glowing?
We actually went to that area, which turned out to be the kitchen, which turned out to be all the eyes on the stove were on.
When you say eyes, what exactly do you mean?
The old coral type electric stoves.
Okay.
They were all on and glowing red.
Did you notice anything about the knobs to the stove?
Did not have knobs on the stove.
Where were the knobs?
I can't. They were either on the counter. I don't think they were on the stove, but I think they were on the counter. They were taken off.
Okay. Did you yourself turn the stove off?
I believe I did. Yes, sir. I had to. I don't know if they were in the right place, but I put the knobs back on there and turned the stove off, and then. Well, you go ahead.
Okay. What'd you do after you turned the stove off?
Lieutenant was over. He was walking across the room back towards what now we know is the bedroom, but he told me, said, open the back door to let some of the smoke out. So I had on my gloves. So I reached up to open the door, and it was locked. So it was pretty warm in there. So I took my glove off, and I opened the door. I believe it had a deadbolt and then a regular lock. So I opened the door.
Locked from the
And,
outside.
At that point, the lieutenant said, come over here. So I had the nozzle.
You had the nozzle. He said, "Come over."
Well,
here.
it
Where
could
did
be
you go?
locked from
I
the
went from
inside
the
as well.
stove
But
kitchen area across what was the
where
living
did he
room
go? Where did he go
Well,
out?
to what
Yeah, but one of the doors could, but the other door is going to have to be closed from the outside.
Yeah.
So, and
Mm.
who would go through the trouble of taking off the knobs?
Well, we have a over here in Sweden. Now he died a decade ago. He was a very, very known arsonist, and one of the things he did was, if he was in a place with a gas stove, put it up to max, remove the knobs, because then it would be harder to turn it off.
That makes sense.
But that is an extremely conscious decision. I mean, I've never seen it outside of arsonist cases that somebody does that.
It just seems like a weird thing to do when you're, let's say, it's really
Robbing a
more
place, yeah.
robbing, and you just got done with a heinous crime. You
Yeah.
thought she was dead, you strangled her. She wasn't dead, so you stabulated her.
Mm.
You decide to take the laptop, ignore everything else, put a blanket on the stove, and throw the blanket on top of her.
Yeah, I mean, not opening any drawers looking for matches or a lighter.
Well, I know it would have been, so 2001, it would have been in its infancy, but you think that since the laptop was taken, they would have looked at her DNA stuff, or not DNA, digital footprint. Was there an email that someone didn't want seen? Was she on MySpace, talking to
Mhm.
other guys?
Excellent question. Why the laptop? That's a very, very, it's almost as if it's personal.
Yeah, well, that's kind of what I'm getting to, but it does seem like those would be things that you would have to say. We give the state all the credit in the world, and they totally know Chris is not the guy, the boyfriend, not the guy. Wouldn't you want to have all the answers to these questions a smart defense attorney is going to ask? Well, did you look at Chris for this? Did you look at his emails? Did you look at their text messages? Did you look at this? You would think you'd have all those things answered so you don't look like a dumbass.
You would imagine so.
Obviously, they are not afraid of looking like a dumbass. It's actually one of my phobias, which is odd considering what I do on the internet.
We now know was her bedroom, and that door was closed also.
What happened next?
We tried to open the door, and it was locked. So the other firefighter that was with me, I think Doug actually kicked that door too. And, I said, when he kicks the door, it's going to roll out, because I knew it was what we call rolling. It was
When you say it's going to roll out, what are you?
the fire. The fire's going to roll out, because when we rolled up, we could see it burning through the roof. So I knew it was pretty intense. So when he kicked the door, I opened the nozzle, what we call Z'd it. I Z'd it down, knocked the fire down. And then they said, I hit it one more time just to kind of cool it down. And I had put my hand, we were just sitting there kind of watching it, make sure it didn't flare back up or flame up or whatever. And I always kept a big rubber band on my fire helmet, and I had a light stuck, up there in it. And I had my hand down on the floor, just kind of sitting there watching to see if it, it was smoke had banked all the way down in this room. And then I turned the light. When I turned my head, I looked down and I saw her at the foot of the bed. And
Can you describe in detail what you saw?
there was a nude lady laying there. Almost looked like, you could tell she'd been in extreme heat. And she was also like a mummy, like she didn't look real. Her hair looked like her hair was intact, but it was.
So I know you said that she was on the floor. Do you recall how she was positioned?
She was positioned with her feet towards the door. Best I remember, we go in the door, the bed was to the left, and then she was at the foot of the bed, and then looked like the flames or the fire was on the bed.
You recall how her body was oriented up, down, otherwise?
She was face up.
Upon discovering the body, what did you do next, sir?
Like I said, we were trained just to make sure it doesn't flame back up or anything. And so Steve and I were still in the room, on the floor. And the lieutenant, which was Doug, he was standing at the door behind us. And he said, y'all don't touch anything, just make sure it doesn't flame back up and back out. So that's basically what we did. We got it cooled down, and then we backed out.
And after backing out, did you, and when you say Doug, is that Doug Whitehead?
Yeah, so he was a lieutenant on the seat that day. He was a supervisor, you might say.
And you mentioned Steve. Is that Steve?
Steve, yes, sir. He was a firefighter also. He and I were on the back of the truck. We had a driver of the truck. We had Doug was a supervisor, lieutenant, and then we had two firefighters, Steve Shellnut and myself, were on the back of the truck.
And after y'all backed out of the room, did you turn the scene over to the police?
Yeah, we called, I guess they called the chief and the assistant chief anyway. The shift commander was already there. So I guess they notified police, and, it just kind of become chaos at that as everybody started showing up, and they wouldn't let us go anywhere. We had to stay there.
At any point, did you take notice of a screen to the back window in the house?
Yes, sir. When we got it cooled down, and I guess I was in shock. I just went to the back door because I had two small daughters. I went to the back door kind of trying to collect my thoughts and whatever. And there was a window to the left side of the door, and the screen, I can't say if it was laying in the yard or if it was leaned up against the house, but the screen had been tampered with. You could tell where it, like if you take a screwdriver and try to pop it out, you can tell where it had been bent. It had been tampered with.
And we don't know that happened any other day.
Yeah, any other day, or when the firemen tried to get in, or get to air out the smoke.
Well,
And here you know what would have been excellent is to bring that screen and show it how it was bent, but they lost it. It was entered into evidence back in 2001, and then it is gone.
Well, also logic it out, Nick. Why would you ostensibly you've created the fire to not only destroy evidence but to possibly take the whole house out? Why are you scrubbing the floors? Why are you leaving the oven on? Why are you putting the screen back in? You think this is all going to go. Why take extra time to do this?
Well, this would have made everything here would have made perfect sense if it happened before daylight.
Yeah.
But the state have to have it happen between 8 and 8:30 a.m. because then they can take into account the supposed alibi of Mr. Melton.
Yeah, and I'm guessing that might have happened in a, graduate house with approximately 6, young adults there at any given time. I'm guessing someone might have been inebriated, left their keys at.
Everybody went out to have a drink, and then when they came back, okay, unlock the door. I thought you had a key. No, I thought you had. Not ashamed to say, it may have happened during my university days. Several times.
If at first you don't
Didn't you have a
succeed.
key? I thought you had a key. No.
All I'm imagining is Winnie the Pooh, where he gets stuck in the tree. I know that sounds terrible because
Yeah.
it's younger Nick, so I'm just imagining, like, lanky
Younger
Nick,
Nick
just
was lanky.
but still just stuck there, and you're like, "Oh, hello, officer. I was just here to say hello, but I forgot my keys. So as we do, I'm going in through the window."
Hmm. Yeah, as Jan says, sounds like the killer knew no one
just a
was
moment.
coming back to the house sooner. Yeah. How about that?
Mr. Freeman, those are all the questions I have for you.
Cross-examination, Mr. Cruz.
Yes, ma'am. May I move the podium,
Of
please?
course.
Ooh, a mobile podium.
Good afternoon, Firefighter Freeman. How are you today?
I'm great. How are you?
I'm doing well. Is it okay if I ask you a couple of questions?
Yes, sir.
You mentioned the back door to the home. I just want to make sure I'm clear on this point. When you opened the door, did you have to unlock the deadbolt and the bottom portion of the door?
With no glove on. Yes, sir.
Would it be fair
You
to say
don't push
that
the
based on
bottom thing into place without being inside.
No, and I do like that he has such a retention of detail that he's like, yeah, no, had they, you know, oh, and John Jackson says that the jury has a question, so if we get any movement, we can pull it up. I haven't seen any movement on the verdict watch screen, but when you do see movement, just yell at me and we'll pull it up. But I do like, again,
Hmm.
and you would think in a
Oh.
very thorough.
John Jackson jury has a question, but I have everything. Let me check. Oh, I can't check X because I know that Sylvia is in the courtroom. Infamous Sylvia
Let me
is
see
in the
if I
courtroom.
can.
Let's see here. No, all I have there, maybe Kathy has.
I'm not seeing it, but
Yeah,
okay.
6 minutes ago, jury question in Georgia v. Faust. But I have it here live.
It might be taking them a little bit to get
Yeah.
everyone back in the courtroom,
Yeah.
so we will keep an eye on it. When they show movement, we will bring it back up. And I do feel bad for the first responders that have to see this, regardless
yeah.
of whether I think the state has proved its case or not. It is the state. This is what pisses me off about these old cases. The state has one chance at this, and
Mm.
like Uvalde, like the Chris Wolfenberger case, and like this case seems to be shaping up, they seem to give a rat's ass about the investigation. They
Mm.
just they found their conclusion and they don't care.
Yeah, there's an unexpected DNA here. Instead of going, okay, first of all, Melton said first on the 19th or 21st, he said, we haven't seen each other since the weekend before. And then he changed that over the years to at least 10 days before. And then he went back to the weekend prior with the added details. Yeah, we had Schmecks at my parents' house, even though he had an apartment and she lived in, yeah.
Well, Nick, you know the thrill you have of being in your twin bed at your mom and dad's house.
But his parents was home. Yeah, no.
Yeah, nothing turns a lady on like the fact that your parents might overhear.
Yeah, because we all know that the American homes are very, very well insulated, so nobody hears anything.
No. Jeopardy and squeak, squeak, squeak.
Door examination of the home, the doors were locked and there was no evidence of forced entry.
Yes.
That would be correct. No forced entry to the doors. Now, like I said, the screen on the window, it looked like it had been tampered with, but no, there was no forced entry to the doors. No, sir.
Sure. Do you recall completing a interview with firefighter report from January 19th, 2001?
The report that I had to write.
Yes, sir.
Yes, sir.
Would you agree? And if you don't know, you say you don't know, and I can show you. Would you agree that you were asked the question 29 in that report, were the doors locked when the first units arrived? Do you remember that question?
I really don't even remember the report you were referring to. I had to write a handwritten statement of what happened that day. Usually the supervisors make out the fire report.
Yes, sir. I am going to show you what I am marking as Defense Exhibit 1. Yes, sir. Thank you. Is it okay if I approach you?
Yes, sir.
Thank you.
Okay.
Yeah.
It's not on my bucket list. I can
Oh,
see
hell no. Jen, there it's also weird to start the fire in kitchen and then close the bedroom door.
Yeah, I mean, so the one thing that comes to mind, and I'm only an armchair psychologist, but in Delphi, they were trying to make a big deal about the branches, the very scant branches being cover or
Hmm.
like an undoing.
Hmm.
Now, it would strike me that if you wanted to do an undoing, put a flaming blanket over someone and moving her to the bottom of the bed. So a place where no one's going to naturally look might be one of those undoing kind of things.
Yeah. Or enough knowledge about house and stuff. And Chris Milton was, according to himself, a contractor plumber. That, yeah, it's very, very strange.
Yeah.
Because the fire was set to buy time, in my opinion. Buy time to get an alibi, maybe.
Yeah, or, maybe it will go unnoticed. I mean, a lot of actually Joel Guy Jr. Kind of calculated when he was planning his perfect crime of premeditation that if you do start a crime or start a fire and it's kind of in the smoldering stages at around 9 or 10 o'clock, it does take a while for it to actually get to the raging fire stage. So it can become pretty involved. And that's what he had planned to do. Because now this was at a time prior to a lot of people working at home. Now, when the police say they canvassed the area, did they look at the Walmart security feed? This neighborhood or her home is very close to a Walmart.
To my, at least not presented in trial, there are no video recordings gathered or presented from that time.
Well, I know it's 2001, so I know that there are a lot of things that are, commonplace now that wouldn't have been commonplace then.
But the Walmart had cameras back then. I mean, but again, this back in 2001, was a small quite a small town by Georgia standards. They didn't,
you would-
and when they talked about, oh, they were black people, black person, which I believe after hearing the witnesses, you saw different people, in my opinion, and the Walmart and everything, and this bright, very, very visible jacket or shirt or both. Was there a construction going on somewhere near?
Well-
Not in evidence.
No, but if this is a, college town, it has a college and then a master's program. So usually there's a regular, bit of the college for your undergrad. You would think that there would be more security around just because parents are spending a hell of a lot of money to send their kids here, and we tend to like security.
Yeah, you would think so.
None of this is adding up, and I doubt it will at the end of the trial, given what you guys have said.
Yes, sir. Were the doors locked when the first unit arrived? Yes, they were. Was there any force of entry? I put no.
Yes, sir. You mentioned the window. I know that it's been 25 years since you responded to the scene. Do you recall what that window looked like at the time that you saw it?
It was a, could have been like a white, seemed like it was a white aluminum frame or vinyl window. It was 2 panes, top and bottom. Like I said, it was to the left of the back door.
Would you recognize that window if you saw it again?
Possibly.
I'd like to show you what's being marked as Defense Exhibit 2 and Defense Exhibit 3.
Yeah, the state didn't show him pictures. That's odd.
Thank you for your patience.
Yes, sir.
And to make sure I have this correct, this window was to the, if I'm facing the back door, it would be to the right. Is that correct?
Left.
If I'm facing, well, let me,
If you're coming in the front door,
okay, it's to the left. Is that
the
right?
window is to the window is to the left of the door that's on the right.
Excellent. I'm going to show you what's been marked as Defense Exhibit 2 and 3. Your Honor, may I approach?
Yes, sir.
Do you
Yeah.
recognize that image?
Yes, sir.
Okay. Is that a fair and accurate depiction of the window as you viewed it on the day you responded to 160 Fun Drive?
Is this the way I found it? Is that what you're asking? I mean, it was just.
Correct. Well, do you recognize?
I can't honestly say. I remember, as you can look at this and tell, it looks like it's been tampered with or whatever, but I can't honestly say that the screen was outside, was not on the window. I mean, over 26 years, I had numerous calls, and I can't 100% say that screen was off. I'm pretty sure it was, but I can't sit here and say, I know it was tampered with because I remember seeing this.
Yes, sir.
Yeah, the
Did you make-
screen was still on the window.
But I do like the way this witness is testifying.
Yeah.
Because a
Yeah,
lot
he's
of
honest.
witnesses, they'll fight. They'll be like, look, so I like that he's like, look, I've slept since then.
Mm.
If you're saying this is what they took a picture of, I remember it being bent.
Yeah, and it might be that they later on took it off and put it and that is what he remembers. But now watching, oh yeah, screen is still on the window.
Yeah. And maybe the police were taking and putting the screen on the window to see if it matched. I don't know why you would
Yeah.
do that and take a photo of it, but sure.
Any notations in the report I provided you? I believe that was Defense Exhibit 1, if I'm not mistaken, about the window screen.
No, sir.
Would you have any reason to say that those images have been altered in any way?
No, sir.
I'd like to show you Defense Exhibit 4. May I approach, Your Honor?
Yes, sir.
Do you recognize
We are-
Defense Exhibit 4?
5 minutes
Yes,
ago,
sir.
we are
You
still
recognize
waiting for the
Exhibit 4 as
defense
the
attorneys.
screen at 160
to the-
Fine Drive. Well, the screen in the window at 160 Fine Drive. Is that correct?
Yes, sir.
Okay. Is that a fair and accurate? Defense Exhibit 2 through 4, are those fair and accurate descriptions of?
Yes, that's looking at this is where I got the idea that it had been tampered with.
Yes, sir. Your Honor, I would move to admit Defense Exhibit 2 through 4 into evidence.
Any objection? They are admitted.
May I approach, Your Honor?
Yes, sir.
May I publish any to the jury?
May.
Law Kong
Tony, thank
says,
you so
I have
much for
some screens.
heroism.
If you take them off, it's an act of God to, to get them back in. Yeah.
Yeah. I mean, my house looks like there might have been a break-in once or twice too, because, boys or cats running straight at a screen because a squirrel teased them. I don't know who was more shocked, the squirrel or my cat. But probably Mr. Mo when I had to explain to him why he had to put the screen back in.
And if they
Any
did,
regret
it
by
should be in a report.
May this witness be excused. Any objection?
No, ma'am.
You are free to go, sir. You may call your next witness.
Doug Whitehead?
Could you get Doug Whitehead, please?
Doug Whitehead.
Doug.
Doug.
Da-da-da-da-da-da. Doug.
Now that's an interesting name. Whitehead.
Yes.
Yeah,
And this
wh-
is a rewatch.
Yeah. I'm here because I'm having a verdict watch.
Sir, if you could raise your right hand, please. Do you swear or affirm your testimony in the matter pending before the court should be the truth, the whole truth, and
Oh,
nothing but the truth?
I've
so help you
started.
God?
I do.
Oh,
This is question number 1.
Okay. Hold on. Let me back up a little bit. Here we go.
Taking a break from my calendar this afternoon to go back on the record with regard to State of Georgia versus Edrick Faust, SU 24-00547. The jury has been deliberating since 12:30, and this is question number 1. To the judge, the jury requests the DNA reports and transcript/video of Ricketts' testimony. Mr. Yamachile, Mr. Bolden, any response before I say what is allowed?
Your Honor, I think the jury has to recall those facts for themselves, both as it relates to the DNA reports. They were admitted into evidence, but I don't believe that they would go back to the jury due to the continuing witness rule. And as it relates to Mr. Ricketts' testimony, the jury would need to recall that themselves as well. That would be the state's position.
All right, Mr. Cruz.
As far as the testimony regarding Ricketts, I do agree. They do have to go off of their notes. But as far as the DNA reports, they are in evidence. I would say they'd like to come out here and look at them, and you could pass it around to the jurors through the jury box. We have no issue with that.
All right, thank you. Okay, so this is the law. The law allows both of these requests to be had. The jury is allowed to rehear testimony, obviously, as long as it's in the courtroom. We're going to queue it up for Ricketts' testimony if they still want to hear it. And the jury is allowed to review anything in evidence, but it has to be, of course, in open court. It can't be, it would be subject to continuing witness rule if it were back in the jury room. But in open court, they are allowed to look at anything that's been admitted to evidence. So I'm going to have the jury come on out, just have them come out, and I will respond to their question in total. Thank you.
So Ricketts was the DNA expert, or one of them, I'm guessing.
Oh, I don't remember.
I'm going to ask counsel to go look at the reports while they're listening and make sure you all are in agreement what we're talking about. Thank you.
I was getting ready to push fast forward, and I'm like, oh, this isn't my screen, and it's live.
Yeah. No, I did have it.
We are back here resuming the trial, State of Georgia versus Edrick Faust. I've already put this on the record, but since you're in front of us, I'll put it on again. SU 24 CR 0547. The jury has been deliberating since 12:30. Thank you all for being on time today. I'm having you out here because I'm responding to your message. And the message reads, the jury requests the DNA reports and transcript/video of Ricketts' testimony. The answer to both of those questions are yes. You can see anything that's in evidence. It has to be done, of course, in open court. The attorneys are going to get together and make sure they know what reports you're referring to and have you look at them out here in open court. But while they are doing that, we are going to replay the transcript of Ricketts' testimony. And there's no video, but the transcript is allowed by law to be heard again by all of you. So as soon as Ms. Satterfield is ready to play it, this is not a perfect system in terms of being able to
They're
sort
actually going
of
to
transcribe
play
it to all of you. And so if it's
That's
faint, sometimes we put a microphone to the actual computer. We'll see how it goes. Thank you.
Interesting.
yeah. In all
You ready?
almost all
Very
other
good. You may
trials,
proceed. Thank you, Ms. Satterfield.
in all other trials, they have to be specific what parts. Otherwise, because Mr. Ricketts was up there for a while, and we have different. If Mr. Ricketts is if it is the cop hiding from the defense, or if it is the truck customs one.
Sir, if you would, raise your right hand and take note. If you swear or affirm the testimony you'll give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? I do. All right. If you would, please speak towards the microphone and just state and spell your name for the record.
William, W-I-L-L-I-A-M, Ricketts, R-I-C-K-E-T-T-S.
Sir, where are you currently employed?
I'm a supervisor with the Department of Homeland Security.
Okay. And what capacity do you, or is there a particular agency that you work with within the Department of Homeland Security?
Yes, sir. I'm supervisor with the law enforcement section of the Transportation Security Administration.
Okay. Prior to working for TSA, were you involved in law enforcement
TSA?
in a different capacity?
Yes, sir. From 1992 to 1996, I worked
Who's
with
the
the Atlanta
groper?
Sheriff's Office, and from 96 to 2001, I worked with the Athens Clark County Police Department.
Okay. And were you working with the Athens Clark County Police Department on January 19th of 2001?
Yes, sir. I was.
At that time, what was your assignment or role at ACCPD?
At that time, I was currently assigned with the Robbery Homicide Unit. I was in transitioning out into training at the time, but I was robbery homicide during that time.
Okay. And were you working on January 19th of 2001?
Yes, sir, it was.
All right. So I want to start kind of at the beginning of the day. Did your assignments at robbery homicide take you anywhere outside of that?
Yes, sir. That morning I was, I believe it was Milledgeville, Georgia. I was at the state penitentiary working out a cold case homicide from, I believe, 1996. I spent the morning there and then drove back to Athens with one of the DA's investigators. I came back to Athens that morning. I would say lunchtime, so somewhere in that ballpark.
Okay. And so just to clarify, though, this cold case homicide you were working from 1996, did that have anything to do with an individual named Ms. Tara Baker?
No.
Okay. you said around lunchtime or so. Was there anything unusual that you noticed when you got back to the police department?
Yes, sir. We got back to the police department, pulled in the background, really parking all of our vehicles and forensics and the CID units were gone, which I told the other investigator that wasn't a good sign for us for the day, and it was not. We went inside, and it's early in the days of cell phones, so we went inside, and I got time to go back out over the phone drive.
Okay, and you said go back out over to Fawn Drive. Was that related to Miss Baker's murder?
Yes, sir, it was.
Okay. And what did you do when you arrived at Fawn Drive?
I arrived back on the scene and met with Lieutenant Durham. Crime scene folks were there. Talked it outside for just a few minutes with folks there. And then I began to talk to Lieutenant Durham, and he took me on a tour of the scene to get a look around so we could start taking some notes and look around. They had already been working for a pretty good bit of time before I got there. He showed me around the location, the crime scene. We looked at that. I took some notes. And then he kind of put me up to where he wanted me to go start doing some canvassing door to door and wanted me to do some other items that he had on his checkoff list that needed to be done.
So I want to start with your canvassing door to door. Did you speak to an individual by the name of Matt Owens?
Yes, sir.
Okay. And then did you also speak with an individual by the name of Tiffany Riker?
Yes, sir.
Okay. And so as it relates to Mr. Owens, what did he tell you about anything that he may have seen that day?
Objection, your second.
Any response to the objections?
Your Honor, I do believe Mr. Owens testified in this trial, and then Mr. Cruz challenged the credibility of certain things that Mr. Owens had said. So I believe that this would be admissible as a prior consistent statement.
I did not challenge the credibility of Mr. Owens. Mr. Owens testified. I don't even ask him about that. I didn't ask Mr. Owens any questions. I just think.
Mr. Yalman, showing any response to Mr. Cruz's statement before making
Your Honor, the defense is contending that he challenged nothing about the truthfulness and accuracy of Mr. Owens' statements, that I don't believe the prior consistent statement would be admissible.
I'm going to sustain it.
Thank you, Judge. Mr. Ricketts, so you spoke with Mr. Owens. We're not going to get into the details of what he said. Did you speak to an individual by the name of Tiffany Riker?
I did.
Okay. What is it that Miss Riker relayed to you?
Objection, Your Honor. Your second.
Any response to the objections, Mr. Yalman?
As it related to Mr. Owens, I don't have definitive memories of ways in which Mr. Cruz may have asked questions or attempted to appease that witness, but certainly as it related to Ms. Riker, there were significant periods of cross-examination, including confronting Ms. Riker with previous statements and things along those lines. So I do think that this would be admissible as a prior consistent statement.
Yes, sir.
So my second objection based on the stated response would be based on the jury's comment. In regards to our examination of Ms. Riker, the only thing we went were the statements that she gave to this officer. There was no need to impeach Ms. Riker on her prior statements because the testimony she gave in court used her prior statements from the day she spoke in temporary witness to establish what her accurate testimony was.
Thank you, Ms. Cruz. I remember the statements, and I'm taking notes on that. I'm going to overrule your objection. I'd like to continue with that one.
So, Mr. Ricketts, as it relates to Ms. Riker, what did she relay to you?
She stated that morning around 8:15 in the morning, she left to go to class. She saw a male subject, black man, walking down the street from the area of Cooper Road towards her apartment. Now, she said the male subject had to stop in order for her to back out of the driveway and go on. Her description, was a medium, average looking height, medium, no hat, medium hair.
Walking while black.
Shirt, baggy pants, possible jeans, but they weren't dark in color. She gave us that description while we were sitting there talking to her. She was surprised that morning, and it was kind of a foggy rain morning that morning. I do remember driving down that morning. I wasn't at the scene during that. That morning was a heavy fall, kind of rain kind of morning, kind of nasty. And she said it was kind of odd to have somebody coming through just the apartment area at that time of the morning.
It was, Was the unusualness also based on weather that she described?
She described the weather and then how the subject was almost walking into her car. It was one of those where if she hadn't seen him, she thinks maybe if she hadn't seen him, they might have run into each other, if that makes sense.
Okay. Did you conduct other canvas interviews?
I did.
Okay. And I'm not going to get into the details of those, but just talking about what you did that day. Eventually, did you end up back at the Athens Clarke County Police Department?
Yes, sir. Lieutenant Durham sent me on several other assignments to take care of, and I did end up back at the police department later that afternoon.
Okay. While you were at the police department, and this would still be January 19th of 2001, is that correct?
Yes, sir. It was.
So while you were in the police department, did you have any contact with an individual by the name of Chris Melton?
I did.
Okay. And who did you understand Mr. Melton to be at the time that you spoke with him?
I understood Mr. Melton to be the boyfriend of the deceased. From being out at the scene, I had not yet seen or met him at this point, but I understood that's who he was.
Okay. And you said by being out at the scene, to your knowledge, had Mr. Melton been brought to the scene at some point during the investigation?
Yes, sir.
Okay. Do you know the purpose for which he was brought to the scene?
He identified the body, which I was told via digital camera from the crime scene. And was out on the crime scene answering some questions there. I believe it's Lieutenant Durham.
All right. Did you have an opportunity to speak with Mr. Melton?
Yes, I did.
Was there anybody else present when you were speaking with Mr. Melton?
Yes, sir. His father came with him. We weren't expecting him at the police department. He arrived, and he and his father were there together. So we decided to do an impromptu interview there at the office.
And where in the police department in particular did this interview take place, if you recall?
We were kind of over in that forensics area. We were not actually in an interview room. We were over in the forensics office. If you think of it, it's like a small conference room. I won't say a common work area, but a small conference room there where we could have a little bit of privacy and a table where we could sit and talk. The area was pretty busy that whole afternoon. Had several things going on at the same time, but that's where we decided to sit.
Okay. So what, if anything, did Mr. Melton tell you about his relationship with Ms. Baker?
So we sat and began to talk.
Just be opportunity to get a response to the objection.
Yes, Your Honor. I believe that Mr. Cruz attempted to impeach Mr. Melton regarding the, status or general place that his relationship with Ms. Baker was in at the time. And so I think that these would be prior consistent statements on that issue.
During our cross-examination of Mr. Melton yesterday, the exact statement he gave to Ted Cruz about his status, Mr. Melton testified to. My concern, Your Honor, as you just saw, was Tiffany Ryder. The state is attempting to use this officer to change the testimonies of other witnesses. That's why we're raising our hearsay objections. Ms. Ryder has testified, Mr. Melton has testified. If it truly is a prior consistent statement that was not elicited or left hanging, which would lead to a misinterpretation, yes, he can bring it up. But just to ask this officer to follow up and give the same testimony that other officers that actually witnesses come in and give themselves, I ask that sustain our consent objection to that.
Anything further before next week?
Just briefly, Your Honor, the prior consistent statement rule for admission has to do with exactly the situation Mr. Cruz just described, as far as the witness having testified, the defense attempting to impeach that witness, and then later that witness's prior consistent statements from the time coming in to show that that impeachment is incredible. So it's the very purpose of the rule.
Yes, sir.
I disagree with that, Your Honor. Prior consistent statement is if I challenge the credibility of this witness on that statement, and then the state comes in and say, hey, he's elicited testimony that the witness has said one thing, but we have a consistent statement from the past showing that his testimony in court is consistent But I would just ask that if there are prior consistent statements that the state would like to use, that's fine. I want to get to those, but just to ask Detective Ricketts what other witnesses told him, would ask them to sustain our consideration.
All right, thank you. I think it's first time in this trial, you both are right. You're both correct about what a prior consistent statement is. I'm going to sustain and overrule the objection. I'm going to do both. So this is what I'm going to limit the state to. With regard to the statements that you are seeking to elicit, they need to be connected to the issue of impeachment and any necessity for a prior consistent statement. It cannot be, for example, as Mr. Cruz has just outlined, an entire narrative of the interview with Mr. Milton. So I'm going to ask you to limit your questioning. Well, I'm going to make a ruling that you have to limit your questioning of this witness to the specific areas that you're seeking and arguing need a prior consistent statement.
Yes, Your Honor. And so I will not ask the witness, what did he tell you? I will try to be direct, which should give Mr. Cruz an opportunity if he has additional objections to bring them up at that time.
That's correct.
All right. So, Mr. Ricketts, I want to ask you very specifically, what is it that Mr. Melton told you about the condition or status of his relationship with Ms. Baker at that time?
That is hearsay without exception. I would object.
All right. Mr. Gallanchilli, any response to the objection?
I was just restating the previous question I asked, and I think it is directed in the manner that the court informed or instructed me to ask it in order to be admissible as a prior consistent statement, exception to the hearsay rule.
I'm going to overrule the objection.
And so, Mr. Ricketts, I'll ask you the question again. What is it on January 19th of 2001 that Mr. Melton told you about the condition or status of his relationship with Ms. Baker?
He said they had a serious relationship and had talked and had intentions of marriage in the future.
Okay. And then, I want to take you forward a little bit. We've talked about the general nature and status of their relationship at the time. What, if anything, did he tell you about the plans that he and Ms. Baker had for that weekend?
Objection, Your Honor. Hearsay.
Mr. Gallanchilli, any response to the objection?
Your Honor, again, it is a prior consistent statement. Mr. Cruz, in his cross-examination of Mr. Melton, indicated that at the time leading up to Ms. Baker's murder, the two of them may not have even been in a relationship. He referred to Ms. Baker as his girlfriend or ex-girlfriend. So prior consistent statements regarding the fact that they were in a relationship and had plans together that weekend that both were excited about would be a prior consistent statement that would be admissible.
Ms. Cruz, anything further, sir?
Sure. Mr. Gallanchilli's purpose for admitting this isn't because Mr. Melton or Alice is inconsistent. That's what an inconsistent statement. It's a statement that matters. Not the general view, not the general theory of the witness. The statement. We did not get into, on cross-examination, Mr. Melton's plans with Ms. Baker on the weekend after her death and following her death. We spoke about the relationship generally. So I would ask that the board to sustain the hearsay.
Yes, sir.
And I would just add, the state had an opportunity to examine Mr. Melton on direct and redirect examination. I think it's inappropriate to now try to bolster or support Mr. Melton's testimony through Detective Ricketts. As the jury has had an opportunity to hear from Mr. Melton himself.
All right, thank you, Mr. Cruz. I'm making a finding that the very issue that the state is asking to have this witness speak about, which is the weekend after the incident, was in fact brought out on cross-examination. The articulation the state has made about what a prior consistent statement is with regard to that issue is accurate, and I'm going to allow you to overrule the objection.
So, Mr. Ricketts, I'll ask you again, I'm trying to make this a specific tailored question. What, if anything, did Mr. Melton tell you about plans that he may have had, Ms. Baker had, for that weekend?
Yes, he went in depth about Tara had plans that evening with friends and family for a birthday party on the 19th to that night, and then he had planned something for her on Saturday night where they were going to meet and get together that
expressed anything to you about their feelings regarding those plans?
Yes, on the Friday, numerous times when we were talking, he said that Derek wanted him to drive down and be there for the 19th for the party at the winery with folks from the law school and for the law firm where she worked. He didn't think scheduling wise.
I am so sorry about that. This testimony is an accurate testimony anywhere in this file. The disadvantage that Mr. Faust has right now, when they're bringing in another witness to testify regarding what Mr. Melton may or may not have said, they have no way to cross-examine Mr. Melton on that information. I would ask that the state ask Detective Brickett's questions related to Detective Brickett's personal knowledge, not information he's heard from someone else, unless it falls under his assumption. But to the last question, to answer our objections.
Thank you, Mr. Cruz. Mr. Gallantilli, I know the witness is in the middle of a statement until that.
Your Honor, I think it's the same argument that the court just ruled on, a minute ago, that this is admissible as a prior consistent statement. And I believe it falls within that exception to the hearsay rule, as the court's already indicated.
Mr. Cruz, let me just ask you a question so I understand your objection. Are you arguing that this information is not elicited with Mr. Melton's on the stand?
I am arguing that the statement that was just made for Detective Briggs doesn't exist in the case file. So what I'm not saying it's intentional.
I'll let you respond to this.
Not saying this is intentional from the state, and I don't think it's intentional. But what's going on here is Mr. Melton testified yesterday. I'm assuming the state didn't get the information that they would have liked Mr. Melton to say, so they brought in Detective Briggs to now come assert Chris Melton, and they'll ask Detective Briggs, well, what did Chris Melton say about this? What did Chris Melton say about that?
Okay, hang on just a moment. Ladies and gentlemen, I want to take a step outside your presence.
That's the elephant entrance. I feel the same.
Okay, it seems like the jury was just wanted to hear that part.
Interesting. I thought they wanted to read DNA reports, or was this a
No.
different Ricketts?
No, I mean, the Ricketts seems to be unrelated to the DNA report, so they
Oh,
wanted both
okay.
DNA reports and the testimony from this Ricketts guy.
Oh,
And if I interpret why they suddenly stopped, it was because the jury said they heard enough.
oh, I was
So-
thinking maybe it was picking up a sidebar and they didn't want to hear the jury to hear the sidebar.
As soon as she can find it, thank you.
Oh, they're going to play more parts. Okay.
I mean, I do like that we can just hear the testimony again. I wish it wasn't recorded on a potato.
Law Kong, were they going to his parents' house for a birthday? No. According to everybody, she was on that Saturday. She was going with work friends to celebrate Christmas because her roommates were somewhere else, and Chris Melton had no idea she was going to celebrate her birthday without him. Yeah, that makes sense. Oh, we were in such a loving relationship. And still she basically tells him to fuck off.
Well,
On her
yeah,
birthday?
and then he goes out with like 3 or 4 different people immediately afterwards, or
Yeah,
pretty much.
and it's a little bit handsy with at least one of them. Right after your Oh, my almost fiance is dead.
Yeah, I mean,
Let's go on a date.
yeah, that just it doesn't it's not a good look.
Thank you, Your Honor. Mr. Ricketts, before we took that brief break, I'd ask you a question, and I'm going to try to, as best I can recall, ask you the same question again. Did Mr. Melton talk to you at all or say anything to you about plans that he and Ms. Baker had for that weekend and their feelings surrounding those plans?
Yes. Tara was very excited about her birthday coming up the weekend. And that she and friends from law school and the law firm she worked at were all getting together at the winery Friday night. And that Chris had made plans Saturday the 20th to meet and take her out and to celebrate her birthday.
All right. And as it relates to Mr. Melton's whereabouts on Friday morning, January 19th of 2001, is that something that y'all discussed in your interview?
Yes, one of the reasons Friday night that he wasn't going to be down is for work on Friday. The new area where he was working and things of that nature was taking time away. He had jobs doing that Friday, so he said Saturday would be a much easier thing. And she had her college law school friends and her law firm friends and all to do the on Friday night.
Okay. Well, and so my question, I might not have been clear, and I apologize for that, is did he talk to you about where he was Friday morning?
Yes, he did.
Okay. And what did he tell you about that?
He spent the night and had spent most of the nights that week with his mom and dad. And it was at their residence. I have the address here if you need it, but he was at their residence that night until they went to work that next morning.
Okay, and I don't think we want to or need to say any specific addresses, but when you say until he went to work that morning, did he talk to you about when that was and where he went on that morning of January 19th of 2001?
Yes, sir. He laid that morning out for me. So his morning was have his helper, his friend Chris, show up to help him that morning at the house there between 7:15 and 7:30. And then they left to start their day.
Okay. Did he talk to you about where they went when they left to start their day?
Yes, sir. His first, on this encounter on the 19th, they stopped at Nash Plumbing first off to load up with gear and equipment for that day, for the projects and the jobs that they were going out to do. He said they loaded up to there, and then they were headed over to try to make a stop over at Truck Customs. Chris explained in the interview that he was trying to get a ladder rack put on his truck, then he had to measure it, and then he would go back later in the day and they would install that ladder rack. I understand the conversation we're having. That location is in Loganville, Georgia, and he went there in order to get that measured out. They left there and went over toward Grayson, Georgia, in order to do a job there, a check for some leaks, that kind of thing at that house. From there, they went on to Forsyth, met up with a contractor there to look at doing a house there at Forsyth. Now, the house there, I guess it wouldn't have boarding on it, but no paper and shingles, I guess, if that makes sense. And I think they were just getting pretty wet. They were going to lay the house out to do the initial plumb on the residence that day. But there was no cover on the roof, so they were kind of getting wet. So Chris said he went back by Truck Customs just to stop in and see if maybe they happened to be ready on his way back to his house. And when he went back to the house, he just dropped Chris there.
All right, any response to the objections?
Your Honor, I mean, I think it's all still responsive to the initial question of what Mr. Melton relayed to him about what he was doing and where he went that morning.
I am going to sustain the objection. I do think it is an error. I'm going to ask the questioner to walk their witness through appropriately.
Yes, Your Honor, thank you. Mr. Ricketts did, so we're at truck customs at this point. Did Mr. Melton tell you anywhere they went from truck customs?
Due to the weather and whatever else, he went back to the residence, dropped his helper off in order to let him go eat and see if they could maybe wait the rain out and see kind of how that would go. He advised that they would be up together later and try to complete some more work or go back by truck customs.
And I'm sorry, let me just ask you some questions as we go along here. So you just testified that he had dropped his helper. What was that person's name?
Chris.
Well, Chris Melton.
Oh, I'm sorry. I have to look back. I apologize.
That's all right.
Give me one second. I'm so sorry.
Objection on the ground that hearsay to the witness has no while he testifies. If the state would like to refresh the witness's recollection, there's appropriate mechanisms to do that. But for the witness to be able to use his notes while he testifies, that's not hearsay.
All right, thank you. Anything from the state before I go?
I think that's correct. We can go through asking those couple questions.
All right, very good. I'm going to sustain the objection with regard to how to refresh a witness's recollection. But I'm going to overrule the objection with regard to having the report on the stand. A witness is entitled to have it on the stand. You just have to use it appropriately. Thank you.
And so, Mr. Ricketts, before you refer to your report, please, indicate to me that you may need to do that. We'll go through the appropriate questions. And my understanding from your last answer is at this time you can't necessarily recall the name of Mr. Melton's helper. Is that correct?
Yes.
All right. Do you think referring to your report would help you refresh your recollection?
It would.
Okay. Please refer to the report. Do not read from it, and just let me know when you've had a chance to review it.
Yes, sir. His first name is Josh.
Okay. So I think, do you recall now, after having reviewed your report, that individual's name?
Yes, Josh McCurdy.
Yes, sir. Okay, so you would just testify that Mr. Melton dropped Mr. McCurdy off at Mr. McCurdy's residence, is that right?
They were back at Chris's house. They needed both the vehicles from my understanding because Josh went there. When they went back to truck customs, Josh, he was going to have to follow him back to truck customs in order to leave Chris's truck there. They would need the second vehicle. So he went to lunch at that time.
Okay. Did they ever return to truck customs?
Yes, sir.
All right. And what did Mr. Melton, what did Mr. Melton tell you about where he went after he left truck customs?
He went to truck customs. He said around 3:45, 4 o'clock for an appointment that he had there. And he got a page that he received while he was there. He received that page, made a phone call, and then went to Athens to the address on Fawn Drive.
Okay. And this, when you say the address on Fawn Drive, we talk about Miss Baker's residence where she was killed?
Yes, sir.
Okay. During this interview, this is January 19th of 2001, did you have an opportunity to observe Mr. Melton's hands?
I did.
Okay. What did you observe about Mr. Melton's hands?
During the interview, while we sat and talked, Mr. Melton, for lack of better words, just picked at his hands and messed with his hands, pretty much just moving glue and things off his fingers from his fingernail beds and just kind of making that kind of movement. while he was with his hands.
Gross.
You can see that. And then I had the opportunity to fingerprint him for prints. And at that time, we didn't use computers like we do now. We had to do manual prints, ink prints.
So I printed him both hands on the printing, pretty much with a desk just like this. Start with outside and work the inside. So I had to hold and sit there, hold his hands, and roll each finger out as I made fingerprints. And then I would move over to the other hand and do the same exact thing, work through all 5. So all of his fingerprints were done there at the police department after we finished his interview.
And you yourself did that rolling of the prints, is that what you just testified to?
I did.
Okay. And I just want to go through that process again a little more slowly. Did you just testify that all 10 of his fingers would have been printed?
Yes, sir.
Correct? Okay. And when you're going through that process, you make contact with the person you're printing?
Sure. So unlike now, you have to take your hand and you hold the print with the finger. You go to the far side and you roll it because you're getting ink. So now with a computer, you can look at a screen and kind of move it around. But with this, you got to dip his hand in ink. You take it and roll from side to side, and then you would move one at a time from finger to finger. So I dip, and roll, and then get the thumb, and then you move around to the other side. And each time you do that, you have to grab the hand, and you have to hold the hand and do it. And they have to kind of hold their hand real loose and kind of give you kind of control of the hands. It's a much better system we have now. At that time, I had to sit and hold his hand during that time while we were doing that.
All right. And so I want to fast forward a couple of days and then rewind back a couple of days. Did you have an interaction with Chris Melton on January 21st of 2001?
Yes, sir, I did.
Okay. And during that interaction, did you and Detective Newton take any pictures?
Yes, we did. We took pictures.
Okay. In particular, on Mr. Melton's hands, when y'all met with him on January 21st, was there anything that caused you to take pictures of his hands?
Yes, he had marks on his hand on Sunday that weren't there on Friday evening when we talked to him. And so
That is an interesting claim.
those also in the rest of his body.
So when you met with
If
him
they
on
weren't
January
there
21st,
on
and you saw
Friday,
the marks, you took
why did you
pictures
take
of those.
pictures
So Detective
of them
Newton,
on
y'all took
Sunday?
pictures.
Yes, on the 21st, we saw those.
Why did you do a full
We did
body
the other stuff we had to
picture
do, and we
thing
also took those
on
pictures.
Sunday if you saw
Were those
nothing
marks on his hands
on Friday?
January
Yeah,
19th,
that doesn't.
2001, when you interviewed him and then fingerprinted?
They were not.
Okay. If they had been, would you have taken pictures of them the way you did on January 21st?
Yes.
Okay.
According to Chris Milton,
And this is a little bit of an
according to Chris Milton, he's been on a work site and he got a lot of these plumber's cement on his hands and stuff. So they were covered in discoloration and stuff. Almost as if he covered his hands with something to hide something.
Yeah, but you would think he wouldn't be picking at it and drawing notice to his hands. You would think if he was fiddling with his hands enough for this detective to notice, he would have spotted, because that's a sign of nervousness.
Yeah, but what if he noticed it? Why didn't he ask, "Hey, let me look at your hands"?
Yeah, that's what it just seems like you're the detective. You're supposed to be the curious one, right?
Yeah. What's all this stuff on your hands? I mean, a skillful investigator, hey, because you probably sat like this, but hands below the table, somewhat peak. Hey, let me check your hands. And then he says, well, we took him and we fingerprinted him. Well, somebody did. Yeah, but he still had stuff on his hands. And
No one thought to take. I mean, and again, I know we didn't have like the digital cameras on our phone at this time, but we did have digital cameras
yeah,
that if he's at a police station, oh, well, first of all, I'd have been grossed out and I'd have probably yelled at him for picking dingleberries off his hands. 'Cause ew, are you 4? No.
yeah. I mean, you're investigating a murder where she was brutally beaten, strangled, and stabbed. Why wouldn't you check his hands on that day? all we have is this testimony. And now he swore it under oath because, and we all know cops never lie on the stand.
True.
But there's so much after the fact here. They went out hard in 2024 with, we got him. Look at this. Look at this black man being guilty. And then slowly and steadily through the pre-trial and everything, things started to get picked apart. And all of a sudden, you have this testimony. Why the fuck would you not record
Yeah,
Chris Melton's interview?
it doesn't make sense.
Because
none
he
of this makes
claimed he
sense.
had an alibi?
Yeah. Do we have did we go by the truck place to see if they had security footage to see, oh, okay, well, he has a receipt. Let's corroborate that.
They don't even know if that place existed. He never showed them any pay stubs. He never showed them, and he didn't remember the phone number to it. And somehow they didn't ask to check his phone. There is literally nothing that says that place existed. There's no, he doesn't have a 1099 from that time, or they didn't ask for it. They simply believed him on his word.
That is insanity.
And I'm trying to go through public records to see, because Logan'sville, Georgia, back in 2001, his parents lived in a fucking big house, 2 stories with a basement. I mean, you can't get closer to an estate than that, more or less. I'm not
Okay, that
entirely
makes more
that's not
sense now.
Yeah, but since they haven't revealed his father's first name, and since he passed away, and I've been checking public records for, okay, and now Chris says he now lives in his parents' house, but I can't find a public record of him having ownership in the entirety of Wharton County.
It would make sense if there was any sort of suspected or a shadow over it. They might have moved it into a trust.
Yeah.
So that, I mean, maybe let's just throw out there that they thought maybe he could be charged with something one day.
Yeah.
That way it protects it for future generations.
Yeah. But no, they have nothing about his whereabouts up until he got to the bank after 9 a.m. They have his friend's words, who at the time they claimed, well, he's my employee or co-worker at this thing, the plumber thingy he was doing. One said, oh, we've known each other for a year, the other one for a month. But that's not inconsistent, because the cop at the time, no, it's okay. And no pay stubs, nothing.
No.
We have jury questions. They are asking then Detective Ricketts to listen to his testimony, and they are listening to all of it. And they also asked for the DNA reports. Yeah, but you will get to it. You will get to it.
Yes.
Mostly through cross-examination. Because the state sure as fuck doesn't do anything to say, to
Oh, that
be
makes
completely honest.
perfect sense.
Yeah, but at the time, you have a guy who picks on his hands, who is forthcoming, but doesn't want to give you pay stubs or the phone number to his place where he collected all the stuff he said he collected that morning for a job as a plumber.
Yeah.
And nobody thought that was suspicious.
Well, not to mention, let's be real, when a woman, ends up not alive, the first
Mm.
person they should look at is typically their romantic partner.
Yeah. What happened in his life and stuff like that.
Yeah.
Yeah, but let's go back to listening to this.
Have you ever worked with plumber's glue and some things related to plumbing?
Sure. So there's primer and there's glue, and the glue gets all.
They have the
over your hands.
detective testifying about plumber's glue.
On the interview on
Yeah.
Friday, I was just watching individuals were interviewing, and he was picking at his hands. One, I think, for concentration and trying to cope, if that's a word. I don't know, but he was just trying to pick at his hands and pull that glue off. None of the stuff that I had.
Why would you have glue all over your hands
I got somebody else, I needed
and nowhere
I have
else?
to clean their hands in order to take prints. So there was nothing on his hands that impeded with me taking fingerprints. So I didn't have to go scrub his hands, which I had to do before, where we had to get somebody and scrub their hands in order to get prints. We didn't have to do that. Blue primer is usually purple, and I won't say it's see-through, but it's not. It doesn't block, and glue doesn't either. It just peels up, and you can have to peel it off.
Well, then let me ask.
So he had purple, according to this. Yeah, he had purple plumber's glue. Now we all seen that on shows, how they mix up and
Yeah.
then all the things. We also see every plumber in existence knows that discoloration stays with you. So you use gloves and something to put it on with. And somehow he got all over his hands.
Yeah, that's what I can buy getting a little dirty, looking like you slaughtered a Smurf village. I don't get. Now, if I were doing plumbing, that's what it would look like all the time. But I'm guessing if you're trying to make your plumbing business work, that you're a fairly competent plumber and you wouldn't spill an entire can on your hands.
This question then. Was there anything about the things on Mr. Melton's hands on January 19th?
And how the fuck does he remember it 25 years later?
Yeah.
No, there was nothing covering his whole. From the picture, you would have had to cover his hand from about where my shirt stops all the way to his fingertips to cover that up, and his thumbs and that area right in there. So you would have had to cover everything. And the plumber's primer and the glue.
Well, he had both primer, glue, and cement on his hands.
Not very good at it, but I got more stuff. But you can see through it. Like if you cut yourself or anything like that, you're gonna see that.
Okay. So I want to go forward to January 20th of 2001. So this is the day between the first day and time that you ever talked to Mr. Melton, and the second day and time that you talked to Mr. Melton. Did you take any investigative actions in order to, I guess, see if you could talk to some of the people that Mr. Melton had mentioned to you about being with him or around him on Friday morning?
Yes, we made phone interviews on Saturday.
They waited until the day after?
As specifically as it related to Mr. Melton's whereabouts on January 19th, who did you talk to on January 20th?
I talked to Josh, and I also talked to Mr. Teeters.
Okay. And you've already testified about who you understood Josh to be. Who did you understand Mr. Teeter to be?
From Truck Customs.
Okay. And is that the Truck Customs that you were making reference to?
Yes, sir.
Judge, I'm going to turn the Elmo off, or can the court turn it off? I just don't want to put something down here inadvertently and have this way. Because I almost did. Thank you. Okay, well, and so as it relates to Josh McCurdy, what did Mr. McCurdy tell you about his whereabouts and Mr. Melton's whereabouts on January 19th of 2001?
He drove to Chris's house that morning, approximately 7:15. He said to 7:30, and he said their first stop was at the plumbing. They went there first. And if I could refer to my notes, I can give you the letters. He also mentioned that they went by Chick-fil-A that morning also.
Do you, and so as you sit here, you have.
Oh, when you get to, well, we're actually going to listen to the cross examinations anyway, so let's just wait and see.
Would help refresh your recollection?
Yes, sir.
But it might take a while because he was on the stand for quite some time.
Let me know when you finish.
Yes, sir.
So I get to listen to this glorious testimony twice.
Yay!
Joy.
So he does mention that they buy Chick-fil-A also for some breakfast.
Did Mr. McCurdy tell you anything about where
I
they
got
We
the
should
Sarah Boone suitcase, and so I need to put Google eyes on it and bedazzle it, but it's going to be awesome.
He said he believed that they were
He thought it was between 8 and 8:15.
Okay. And from there, did he tell you?
We
anywhere
should
that
not
they
be
made
on spoon
contact?
together.
He mentioned Forsyth and the place with the rain, and he was talking about just how wet they were getting and weren't able to get in out from underneath that rain. He said that it was just too much rain to get any work down there.
If you haven't
And so
watched the trial,
Forsyth, did Mr. McCurdy say
Chris
anything about
Melton
where they
takes the
went
stand.
next?
He did mention they went back to truck customs that afternoon.
Train wreck on trial.
Forsyth in truck customs.
They did stop for lunch for the lunch break that they mentioned earlier, but I didn't mention that.
That's absolutely not a cop reference.
And then did Mr. McCurdy say anything about anything that happened while they were at truck customs in the afternoon?
He mentioned the page
Good point, Karate Cat Mom.
in detail, and then he talked about how they left Chris's truck there and he drove him to Athens. He didn't want Chris to have to make that drive, but he drove him all the way to Athens.
Did he say anything about any fears that Mr. Melton had or any actions that Mr. Melton took as they drove to Athens?
You know, he said that while they were in the truck that Chris was calling information, trying to track down other parents of the girls there, trying to make contact as he drove from that area. I have to say Loganville because it's easiest to put there, but as they drove down from Loganville to Athens, he was trying to get information and see if he could make contact with family members.
Okay. And did he say anything to you about any types of worries or fears that Mr. Melton had?
Objection, Your Honor. Hearsay.
In response to the objection.
Judge, under 24-803-5, past recollection reported. I believe yesterday during Mr. McCurdy's testimony, the foundation for that was laid, and this would be that past recollection recorded being admitted under exception to the hearsay rule of 24-803-5.
Yes, if the defense wanted the under the same exception later in trial, then what happened?
So, 803-5 is not a blindness case. The state, if they wanted to use as a court of recollection, is not Detective Bridges. They would use it with Josh McCoy. They could use it with. I'm becoming concerned that the state is trying to use Bridges to ride everybody else's testimony. So I was just asking the court to instruct the state not to elicit hearsay with something that's a personal observation of Detective Bridges that's lawful, that's legal. As far as just going through witnesses and saying, hey, what did they say about this, what did they say about that, I believe that is wrong.
But your objection is hearsay.
It is.
I'm going to sustain the objection.
Yeah. Later in trial, he tried to use it the correct way, and she still sustained it against the defense.
Talk to you. You've already mentioned that you had a conversation with Mr. Teeter, is that right?
That's correct.
Okay. I don't think we need to get into the contents of that conversation. But I do want to go forward with you to January 21st of 2001. Did you have contact with Mr. Melton again on that day?
I did. He voluntarily came back and met with us.
Okay. When Mr. Melton met with you, did he have anybody else present with him?
His family was with him, but they came back with him, but his dad was with him.
Okay.
Yeah.
When you
They-
spoke with him,
His dad was there on the 19th interview, and both mom and dad went there on the second interview.
Wasn't he
And they
24?
never separated them.
Yeah, but wasn't he like 24, 25?
Yep. With his own apartment.
Yeah, why are mom and dad there?
We went back over the timeline of events from Friday, and Chris added that he had stopped by the Wachovia Bank, Loganville, just after
Perhaps
9.
because they know their son is a fuck up,
Which we took note of that, and then on
which you will
Monday,
hear about.
other detectives went to run that to ground. That information went past on Friday, but Chris talked about it with me on Sunday. Everything else pretty much stayed the same except for that.
All right. And so when he was meeting with y'all on January 21st, did anything come up regarding blood sample?
Yes, toward the end of our conversation at the police department, we talked about the crime scene, things of that nature. It's the first time that I brought up with Chris that there was the possibility that Tara had been sexually assaulted. We had a brief conversation about DNA and some things of that nature, and I told him that at some point we would need to get consent and he would need to do a sample for us, and he agreed. So the warrant wasn't necessary, but he agreed to go with us after our Piedmont Hospital to do that.
Did you attend or observe that blood draw?
I did. We went there. They followed us over. We made contact because it was a Sunday, and we had a nurse in the lab do that for us. And I observed both vials be drawn, placed the evidence bag, and then I took them back to the police department and placed them with the evidence.
Did Mr. Melton make any statements to you about the last time he and Tara had sex?
He did. From going over my notes and listening to the recordings, I can't give you a precise date. His voice trails off there, but it was in that week period of time, sometime between that last weekend. I want to say it was Saturday or Sunday would be my best recollection. That the recording goes off, kind of. That might be the second quarter. Oh, good.
Sorry,
That's okay, sorry.
cut you off there. Let's talk about the tools that you had in 2001. Obviously, nowadays we all walk around with these guys that have a recording function on them. When you were a police officer in January of 2001 and you needed to record an interview with an individual, what equipment were you provided with in order to do that?
We were using micro cassette recorders. Audio wasn't always the best, but we did pretty good on it. You can listen to them. It's pretty hard to. We used those. I laughed talking to some of the officers with the Ranger this morning. They didn't understand that this was the first area of time when we were doing these reports that I wanted was word processing. So if that makes sense, we've done everything else before that with typewriters. So word processing was kind of new, and we were using micro cassette recorders, which weren't great. Atlas Clark County at that time was in the process of putting up interview rooms with video cameras and things of that nature, but they weren't. That was not the norm.
So, I mean, is it fair to say that this was a period of time when, like, the use of technology and the tools that y'all had available was in a period of transition?
Huge.
Yeah. So as you were there on January 21st, I want to go and retrieve some things from evidence and show them to you. So if you bear with me for just a moment. Okay.
For you guys who has been with me and watched this,
All right.
now when the door is opened to playback testimony, Chris Milton said something really interesting during his testimony. That after a vote in my chat, over 70% heard that Chris Milton said on the stand that he said it in first person, I don't want to look at the devastation I had caused.
Oh. Yeah.
And the state claims, no, he was talking about the other person had caused. This was during closing arguments. But I hope the jury wants to have that played back.
Yeah, I mean, I guess since I haven't seen the trial, I do wonder if this witness in particular didn't come off as incredibly credible. Or
do you remember the that we heard trial when
yes.
Amber Heard tried to cry on the stand?
Oh yeah. Yeah.
And yeah, same here.
Oh.
Oh, he's so devastated. Oh, he was so devastated. He crumpled up and closed his eyes, and oh, so devastating everything was. And then during an objection, he just what?
Oh, I mean, most of the time, men have a hard time expressing those emotions. You'll find them maybe like going out by themselves, or things like that. What you don't typically hear is them say that they collapsed or cried. Maybe I'm just going by Mr. Moe, but yeah, that's not how he would say things.
Yeah, and you will see it when you get there, but the first question on cross-examination from the defense was, why was there no tears?
Yikes.
Mr. Jingles, you need to stop booping with your claws out. It really, really hurts. Okay?
He says, I'm sorry, I'll do it again in 5 minutes.
Oh, yeah. He has never been able to boop without claws. It's just
He's like, I'm sorry you're hurt by me.
Yeah.
But I will continue to do it.
All right. Oh, we are 8 minutes behind. Let's play this in 1.25.
exhibits. They both have been admitted into evidence already. They're defendants exhibits 29, and then, I'm sorry, I said two exhibits, two sets of pictures. So D29 has been marked collectively, so all the pictures are D29. And then I'm also going to hand you defendants exhibit 37, 38, 39, and 40 that have been admitted into evidence already as well.
Yeah, this is when they are showing the photographs of his hands after he
Just let me know when you've had a chance to look through them.
mysteriously punched his wall, because they went to his apartment on the 20th, where he punched his wall 30 times through the inner wall to the concrete outer wall. And that is how he explains all the scratches on his hands.
Except those don't look like, because you would bruise. Those look like scratches, not blunt force trauma.
The scratches and bruising. But here's the thing: if you try to fight a concrete wall, you will lose, and then you will go to the hospital. You never went to the hospital.
Yeah, because you might get lucky 1 or 2 times, but out of 30 times, you're going to break something.
And yes, Jen, they did show pictures of his hands. Well, I do think they showed it. No broken bones, but his hands are filled to the brink with bruising.
Yes.
With bruising and especially scratches on top of, on the back of his hands.
Was there any explanation provided by him for where those injuries came from?
I talked to him about those.
And they did show pictures of his, well, not to us, but to the jury, about the holes in his inner wall towards the concrete wall.
That doesn't make sense.
Yeah, and I mean, if he punched that large of a hole, and he never solid wooded or any stubs or anything.
Not to mention, again, 1-2 loud thunks in an apartment, maybe. 30, someone's calling the cops.
Yeah, and his parents were there and didn't stop him. They just looked at him punching through the wall because he was so emotional. He was so emotional that he had to get it out of his system. So he started punching the wall. And the defense then said on cross-examination, so when you're extremely upset, you go to violence?
Dang it.
I mean, the Chris Melton testimony. I mean, I was maybe 20 minutes into, maybe half an hour into Chris Melton's testimony when I just said, yeah, he did it. Nicola Cox, yeah, there is some swelling to his hands, but if you're punching into a concrete wall, you break things. There's no way about it. You will break stuff. He never went to the hospital, no casts, no anything. So I would submit to you that those are the injuries of punching something softer than a concrete wall.
Yeah, that just it doesn't match.
And I do believe that this cop, when he's trying to recreate what he saw on the 19th, he was so convinced that this guy had nothing to do with it, so he didn't actually. I mean, the human mind plays tricks on you. If you're not expecting to see something, you probably won't. And when it comes over here, it's called the chanterelle thing. Because if you're out in the woods trying to find chanterelles, you will find nothing. You can walk around for hours and find nothing until you find the first one. Then all of a sudden, oh, there's another one. Oh, there's another one. And that's the mind playing tricks on you, because If you don't
Yeah.
expect to see it, your brain does not register it.
Well, yeah, and it seems interesting that a detective would note him playing with his hands and picking at his hands as a self-soothing thing, but not dig into that. You would think that it would kind of be your natural inclination to say, "Oh, is that something you do when you're nervous?" Or, "Oh," or
Please let me look
probably
at your hands a bit closer. You
yeah,
are investigating a murder where the victim is brutally beaten up.
yeah, you would think that would be something you would be paying attention to. It's something I find myself noticing, but I'm a weird person, so
All right, we keep getting further and further back.
Us?
I wonder why.
Secretary, thank you so much for your time. I don't have any other questions for you right now, but I'm sure Mr. Cruz may have some.
Mr. Cruz.
Yes. Why don't we take a 10-minute recess and allow everybody to use the restroom? We'll be off the record until 2:25. Don't discuss the case.
And I guess they are now moving forward. Hey, they are jumping ahead. What is Mr. Cruz working on while while the jury is listening to this?
I would be curious.
Yeah, but maybe motion for appellate issues, motion for completing the record, motion for what do you call it? Completing the record.
Now, do we know the breakdown of the jury? Like men, women, black, white, furry?
The one that I heard, it is 9 men and 4 women.
Okay.
That makes 13, I know, but I do believe the jury it should be 12 plus 2. Yeah, it could be another client's case he's working on, but I mean, you don't do that when your client is beside you.
Yeah, typically I would be a little irritated, even if you're
Yeah.
faking it.
Now, I would assume he's working on something on this case. Or if he's writing down how the jury is reacting. Could be that. Okay, I think I can skip ahead. No. Here we go again. Yeah.
You were with ACCP, is that correct? That's correct. And during the time of this investigation, you were with ACCP. That's correct. Would you agree that ACCPD dropped the ball on this investigation? Yeah. You believe ACCPD followed from all leads? Yes. Confirmed all information? I think so. I would like to add something to that if you would allow me to. I can't answer any questions. We can talk about it after those. That's okay this time. No, I think I'll answer that question. Yes, I wish.
They are talking really, really fast all of a sudden.
Fresh out here 25 years ago, yes, things would have been done totally different. I think with some options and things that we've had. Everything that I can say to, and I will not answer on behalf of ACCPD,
But on the days that I was a part of this case, I would say, I think yes, we did. But I think if you look at anything 25 years back, I think if you look at something I did last week, there'd be things that I would like to improve on. But I don't think drop the ball would be a word I would ever use.
Sure. Do you believe ACCPD followed the evidence appropriately?
Yes, sir. The evidence, to my knowledge, I believe they did.
And I'm assuming that you met with the prosecution before you testified today, is that right?
That's correct.
Do you or ACCPD feel the need to justify why Chris Melton was not arrested?
No.
Do you or ACCPD feel the need to have to defend Chris Melton?
I don't believe I'm here defending Chris Melton.
So that is a yes or no question.
Please repeat it.
Yes, sir. Do you or ACCPD feel the need to defend Chris Melton?
No.
Do you or ACCPD feel the need to defend the state's case?
No.
So I'd like to ask you some questions about a couple of things that you talked about on the record examination, okay?
Okay.
For starters, would you have any reason to disagree that January 19th, 2001 was 9,153 days ago?
Sounds appropriate.
And I'm going to use this whiteboard over here.
Yes, sir.
So 9,153 days since 1/19/01. Fair?
Sounds correct.
In 2001, can you tell us what team won the Super Bowl?
I cannot.
In 2001, can you tell us what team won the World Series?
No.
In 2001, can you tell us what your favorite song was?
No.
So no to Super Bowl and forget my handwriting. It's terrible.
Now, this is very common with cops. They have perfect recollection on the state's case or the state's questions. It's weird, isn't it?
Yeah. But they're totally not helping the state.
No. They are just there as neutral witnesses. Heather, I have never seen played back like this in court.
No, I was just about to type it because I didn't want to talk over any
Do
testimony.
you agree that your notes say nothing about Mr. Melton picking anything off of his hands? Is that correct?
No, sir. I'm going back from the recollection of the audio cassette tapes from that day.
So your statement to this jury is that based on the audio cassette of that day, it refreshed your recollection that Mr. Melton was picking items off of his hands.
Yes, sir. You asked me about the Super Bowl. Not an NFL guy, not a baseball guy.
That's all.
Crime scene for Tara Baker, I'll never forget. The interviews.
This yes or no question.
Well, Judge, your question.
Witness is allowed to explain his answer.
Have you heard on that, Johnny?
You may be, yes.
I would disagree with that. The witness on cross-examination, my job is to posit to the witness yes or no questions. If the state wants the witness to elicit further testimony, they do that on redirect. And at this time, Your Honor, I pretty much give the witness what the answer is. They can answer yes or no, and we decide which direction we go from there. So I would ask that the witness is not allowed to control cross-examination, to control Mr. Faust's rights to cross-examination, and we're allowed to ask the witness leading questions that the witness answers appropriately.
Okay, so this is not about witness control, this is about what the law allows. And cross-examination questions are yes or no questions, certainly. But the law allows a witness to answer yes or no and then explain if he or she chooses to make an explanation. And so I'm going to overrule your objection. He is allowed to explain if he chooses.
I don't think that is actually completely correct. Yes, they are allowed to answer how they see fit to some extent. But when it comes to explanation, that's up to the prosecution on redirect. That is every trial I've ever listened to, including the 3 or 4 I've watched in Georgia, has always been, sir, miss, please answer the question from the defense.
Yeah, not. I think based on something or other, you don't have to answer this question if you don't feel like it.
She makes really, really strange decisions.
If there are further objections the court needs to make with regard to those explanations.
Oh, and before I forget it, thank you to Vetlemai for buying 3 coffees on Buy Me a Coffee. Thank you so much. And to Marilyn, who bought 1 cup of coffee about an hour ago.
Oh, okay. I
Yeah.
probably won't be able to find that one. I could find the other
Yeah.
because I've
No, I
been
did
trying.
post it. I did post in my chat when it
Oh,
happened.
okay.
And
Well,
I
I've been
have
trying to.
Yeah, and I've also wrote a reply on the Buy Me a Coffee website. Hey. All right. So thank you so much. And well, okay. And yesterday we, when we watched over at my channel the Laura Owens bankruptcy case, we found out that her podcast made $83,000 when she and her mother had that a few years ago.
What are we doing with our
$83,000.
lives?
Folks, here's a challenge for you. At least half of that each for me and Mo, 41,000 in 1 year. So let's make this 2026 where we beat Laura Owens' income from what we do on
Yes.
YouTube. That 83,000, that is her claim. And she claimed it apparently in the deposition regarding the Clayton v. Eckert. And then in the bankruptcy court, she also claimed that she made no income whatsoever the past 3 years.
You know, I'm pretty sure the government can figure that one out.
Yeah. It's very, very interesting. So that is the challenge for our viewers who are much better informed and everything than Laura Owens' audience on her podcast. Neither of us would mind half of it each.
I would not say no to
I
it.
would not say no to $41,500 in income from my channel in 1 year. Let's just say it. Jokes aside, as I always say on my channel, always appreciated, never necessary, especially not if you choose between bread and me, choose bread.
Yes.
Now, if you choose between 3 Starbucks coffee on a Monday, give me one of them.
Yes.
All right, we are getting so behind.
You'll ask the questions, Mr. Cruz. Thank you.
Sure. Now we'll draw that question. My understanding is the audio is what refreshes your recollection in regards to what was on Mr. Thomas' hands. Yes. And that audio is from January 19, 2001. That's correct. Okay. And you've already listened to the audio because the state provided you with a copy. Is that correct? Yes, sir. Okay. And if you were to hear that audio, you would recognize it. Is that fair to say? Yes. Or is it no?
This is more interesting, to be honest, since it's current.
If they listen to all of this, then they can go home for the day because it's going to be a while.
Well, that's what I was thinking. I know I was wondering if we would get a verdict today, but I don't think so.
Yeah.
Once you listen to it, we feel comfortable that you recognize the audio, just look up, okay?
It seems like they want to check out what they are saying about Mr. Melton. And then they want to watch the report, the DNA report. Why was Mr. Melton's liquid DNA or DNA at all in her back door? No matter
Yeah,
how it got there. If he had schmecks with her Saturday
but
night.
it's closed. It's not. It's closed.
It's designed for outward motion.
Yes, and so even if you have gravity, it's not going to end up inside in here.
Yeah. Folks, I know this comes as a shock for some of you. Women poop.
Not to your knowledge. I refute that. Just kidding. But yes, we do.
That's Vetlemar. Did they check Melton's DNA in 2001? They collected it back in 2001. But when they tested DNA at the lab back then, they didn't get any results or not enough results for any positive match whatsoever. Wait a minute. I don't know if they actually checked. But to my understanding, the results back then didn't make any positive at all. So they couldn't match it. But then again, well, why didn't they check for the mitochondrial? Some
Or
alleles.
even blood types.
Yeah, blood
typing.
types to narrow it in.
Yeah, because are you telling me that Chris and Mr. Faust have the same blood type? Do we know if he's an excreter? I mean, there was a time before DNA where that's all that the police had to go on.
Oh, Jen says DH looked up some medical studies. 13% of specific cases they looked at had things going up the back door. Sometimes it was from poor collection techniques, like the swab contacting outside first.
That makes sense. You just think if you weren't getting any answers with the high-tech stuff, you might go back to the low-tech stuff.
Yeah, you would think.
Because even then, you could have said, okay, well, this doesn't eliminate Chris. Okay, we probably need to look more at him.
And one thing that amazes me is that the swabs they took from mouth, the supposed vagine and back door, the test they claim is from the vagine, didn't have Tara's DNA on it. Yeah.
Also, I will never willingly buy myself a shake weight, but if one goes to my P.O. box, we'll see. I expect many cash donations, though, because if I'm going to disappoint my parents, I expect to be paid for it.
All right, let's continue. We are both commentary channels.
Yes.
And that's why we are always behind. Yeah, the notion was, regardless, he said he had an alibi. And even if they checked it, it was supposed to be there.
Thanks, JKD Buck. The P.O. box or the post people already think I'm nuts because they're like, your name's not Mo. And I was like, I understand that. I don't put my real name out on the interwebs.
As Mike says, Athens is a very racist county. Or Athens, Georgia. And they took Chris's word. Yeah. And remember, it was happening that somebody saw a black guy.
And Garrett Warhartz, we've got jury question. They're still deliberating, and they wanted to hear all of Detective Ricketts' testimony and also the DNA reports. Although I don't know if they're going to play the actual testimony or give them the reports to look at.
Yeah. The DNA reports are separate from Ricketts' testimony. So now they're just listening to his testimony. So it's 2 jury questions: the DNA reports and Ricketts' testimony. Yeah, and contrary to common belief, now my name is out there already, but yeah, I shortened it to Nick.
Well, and you left out which is, what every American assumes Swedish sounds like because of the Muppets.
Oh, but I understand. There was a wild rumor a while ago that Swedes hate the Swedish chef from the Muppets. No, we love him.
See, and here I thought that the Olympics were gonna be really interesting because I thought Sweden and Canada, like 2 states that never are not known for, like, their aggression, I thought curling was gonna be the start of I was like, "Do it, do it."
Yeah, we are very, very calm people until it comes to sports. Then the old blood shows up.
Yeah, you could say you were the first traveling team, if you will.
We only went there to, hey, can we park here? Lindisfarne was a pure accident. They just sailed by and saw this church was on fire. So they went in and they saved all the gold and the women and brought them
Yeah.
aboard for health reasons.
Yeah, they were like, "Hey, hot chicks, only the hot chicks."
Yeah, have you seen the Brits nowadays? My answer.
Hey,
And look at the Swedes. Yeah, we took the
I was
pretty
about to
ones.
say, it takes a lot of different genetics to make Bella Hadid, so congratulations. And then she decided to marry someone from One Direction. Or what's his face? I don't look. I have calmly and gloriously gotten to the age where I don't know who anyone is in Hollywood, and I am A-okay with it.
And it's only through my younger sister I have any idea what One Direction is.
Yeah. I wish I didn't know it.
And all of a sudden we are 20 minutes behind.
Us?
Yes, sir. His father. Does this sound like a fair and accurate rendition of that recording as you remember it? It does. And what I'd like you to do is going to mark that flash drive, which has been identified by the witness as an interview between Detective Ricketts and Chris Mountain on January 19, 2001. That's the sensitive 44. what has been marked as Defense Exhibit 44. So this is what I want us to do with this detective briefs. I'm going to allow you to listen to this. Okay? And can you look up at the portion where you discussed with Chris Melvin what's on his hands? Is that there? Yes. And just to make sure we're clear, this recording, based on your prior testimony, this recording refreshed your recollection about Mr. Melvin picking his hands, what was on his hands, things of that nature. Is that fair? Yes. May I brush the windshield? Okay. And if you would, once you hear that portion of the recording, just let us know the timestamps.
The Colin Gray trial. The father of
Yeah.
Colt Gray.
Yeah. It's a slippery slope.
Yeah. Yeah.
Again,
because-
if they can prove that they knew that
He
this
knew.
father
actually
that this-
knew was at least was a high risk that his kid was going to do this instead of a multitude of other things, sure. But at the same time, at the school, a teacher got so worried she pulled him into the principal's office or the vice principal's office. He went there with his bag, with everything in it.
after the Crumbly case,
Yeah, and they had cause to search it, and they didn't. And he walked off back to the classroom, then asked to be excused, went into, yeah.
you would think after the Crumbly case and what came out, and that no school, when they had a suspicion, would send a kid without looking at their backpack.
Yeah, and the Crumbly case is a Foster clock in itself. I mean,
Yeah.
the prosecution gave immunity to the school, everybody who testified for the school.
Yeah. It's very much like Uvalde, except that isn't this child still alive? So
Yeah.
he will face justice.
Yeah. He will.
I guess I can understand going after the parents civilly. I can understand that. But you would have to make a very compelling case that this father was habitually, negligent with his force multipliers, that he,
Yeah. But he was and Colin was a single parent because the mother had her drug issues and other issues, and she was even ordered by a court to stay away from the entire county because she misbehaved so badly. But they are still going to bring her into court to testify. Yeah, convict my ex here.
If you want to make an argument that the instability or neglect was a factor, then wouldn't the mother be more culpable?
Yeah. It's that's a different case, and
yes,
a different.
We are never gonna. We will be reporting from 9:00 at night. Well,
yeah. If I have time, I might do something this weekend.
Yeah,
We'll take that. If you need to listen to it, we'll take that. We just want to know we're in there recording. My recollection is toward the very end of the interview, which is pretty usually, like I said, I can get time. But yes, you speak through it. Anytime it's 4208, if that will help. Pardon me, sorry. 4208 is the interview ending time, if that will help.
No verdict yet, Dave. Or it might be. We are 20 minutes behind. Now they're just shuffling papers again.
Sure, probably. Sure.
we're watching them live right now, but we are behind by about 20 minutes.
Shuffling papers.
4048, start at 4048 and play it to 40.
So now we're going to listen to a recording of a recording. That will go well. Oh yeah, Linda. Yeah, this is actually somewhat live.
And you would agree that the statement that you made led you to say that Chris Melton was picking things off his hand, that he had different blues on his hands, was you need to wash those things up or anything? Is that you?
Yeah, I believe I said, do you want to wash those things up? Is that?
Can you write that down? Do you want to wash those things up?
Yes, sir.
And that is minute mark, you would agree, 4048 to 4051?
Yes, sir. That was both. Thank you.
You're welcome. Your Honor, I would move to admit the defense exhibit 44 for the purposes of moving minute mark 4048 through 4051.
Any objection?
No, Your Honor.
Is admitted.
Thank you, Your Honor.
And just to clarify for the record, it's my understanding, Mr. Cruz, that you're just seeking to admit those 3 seconds of the recording.
Right. For now, we're gonna admit more, but for now, just those 3 seconds. So, the statement, do you want to watch those things? It says nothing about picking at fingernails, correct?
That's correct.
And we've agreed that it's been 9,153 days, right?
Correct.
It says nothing about picking off his skin, picking through all his skin, is that correct?
Yes.
Okay, it says nothing about whether the glue is transparent or not.
Yeah.
Okay, would you be shocked to learn that Mr. Melton testified himself that he had semen on his hand?
No.
Okay, but that would be inconsistent with the testimony that you just gave the jury here today, is that correct?
No, plumber glue, plumber semen. I would categorize it the same thing.
Well, he said 3, and he included bones.
Okay.
Yeah, on testimony, Mr. Milton said plumber's cement, plumber's glue, and one other thing. So he was,
Yeah,
and
I
folks,
mean,
that was just after half a day of working, because then somebody called him, and then he went there.
yeah. And he got his hands.
It's
Well, no,
almost
his
as
hands.
if he covered in plumber's stuff, almost as if he shit my hands and dipped them in something.
Yeah. I mean, call me
Primer,
crazy.
the purple stuff. So purple stuff plus cement. I mean, on the back of his hands? Seriously? I would claim it is to cover something up.
So, would that testimony differ from the testimony that you just gave the jury on direct examination?
I don't think so.
That's fair. 9,153 days. We don't remember the Super Bowl. We don't remember the World Series. We don't remember our favorite song. But the simple statement, do you want to watch those things, led you to tell the jury that Chris Melton's hands you could see. Is that right?
Yes, sir. It was the totality of this interview, sitting in that interview room, looking across the table at a dad and son, and Chris, as he would make comments.
And why are they on first name basis?
Yeah, that's the other thing.
Kick at his hands and pull. And it was just, I won't say a nervous tick, but it was what he was trying to do, I think, to keep his focus, would be my opinion. That is what we're talking about with there. We're ending to end of the interview where I've got to get fingerprints, and I just asked him, hey, you want to watch those things up? You want to get that stuff off of there? That's all it was. If he'd have had a high amount of semen or whatever else on his hands,
It's not responsive in there.
I'm going to sustain the objection with regard to non-responsive at the end of this particular statement.
What you just stated, that's nowhere in the police report, is it?
yeah,
You have your reports, is that right?
that's correct.
It is not an audio recording you've heard, is that correct?
That's correct.
Okay. And as far as the evidence that you personally provided in this case, the very first time you've ever made that statement is before this jury here today, is that correct?
What do you mean?
Sure, based on your notes and based on the audio recording. You have never said before that Mr. Melton was picking at his hands, picking items off his hands, is that correct?
No.
But we would agree, 9,153 days later, you stated, is that correct?
That's correct.
Isn't that
You also
strange?
stated on direct examination that Mr. Melton wanted Miss Baker at his, excuse me. You also stated on direct that Miss Baker wanted Mr. Melton at her birthday party on Friday, is that correct?
That's correct.
Did you interview Miss Virginia Baker?
No, I don't believe so.
So you're not aware that, but you did not interview Miss Virginia
only people I did were some roommates and other folks who corroborated what Chris said for me there.
Do you know if Chris Nelton had talked to those roommates and told those roommates the same thing he told you?
I would have to look at my notes, but one of them mentioned it to me in her statement, I believe.
Sure, but tell us the date that she mentioned
Okay.
that.
Give me one more second, just to make sure I give you a good direct answer.
Absolutely.
And some more shuffling of papers.
What I've got about the, so those statements aren't going to be about the birthday party, and I don't know if you want me to read what I've got about the relationship with Tara. I don't want to say it. So I don't have anyone do what you said. So I'll say no to that because that's on a different relationship.
No. So the specific answer to my question is no. No one else said anything about Mr. Nelton.
To my knowledge, no, then it was a different statement.
So the statement that you gave on direct is inconsistent with your notes.
Which was the statement I made on direct?
That Mr. Nelton, Mr. Nelton and his baker had plans on Saturday. Is that correct?
That's correct.
Okay. And I asked you, I'm paraphrasing, had that been corroborated by anybody else? Is that correct?
That's correct.
Okay. And your answer to that question is no.
Yes, that direct question, yes.
Okay. So you just simply took Chris Melton's word for it. Is that fair to say?
Yes, that was my point.
So he trusted Mr. Milton's word, but from other witnesses, we know that's false.
Yeah, and wouldn't it be trust but verify? Even if
Yeah.
he's a witness and not the prime suspect, wouldn't you still trust but verify?
But he's a nice white boy who says he had a loving relationship with her. That's enough.
Hmm.
Everybody knows white men do not rape, do not murder, do not arson. I checked the statistics, by the way, regarding arsons. It is almost exclusively white people. There are cases.
We're number one.
And
We're
we're
number
one. Now, there are some big cases where we also see people, non-white people, do it. But when it comes to the everyday arsonist, almost exclusively white.
Yeah, and I mean, the other thing that most crimes, even though it doesn't get talked about, is you stay within your demographic. So
Mm.
white people tend to more exclusively kill white people,
Mm.
you know, percentage-wise. Now you have outliers and you can play with statistics, but typically, if you're going to offend, you typically stay within your own demographic.
Yeah.
Do you think in a criminal investigation, especially involving murder, aggravated assault, burglary, aggravated sodomy, arson, it is important to take more than someone's word? Is that fair to say?
Yes.
And I believe this, I believe the question I asked you about Party Friday. That's what we're talking about, not Saturday, Party Friday.
Yes, sir.
So just to clarify the record, the fact that Tira went Mr. Melton at the party Friday, that was based on Mr. Melton's word. Is that correct?
That's correct.
And the same for Saturday, is that right?
Yes.
And Mr. Melton did not provide any proof of any plans he had with Ms. Baker. Is that correct?
Did not.
I'm going to allow the questioning that the court has advised us to be cautious about. Can me and Mr. Chili approach the bar, please?
Then they are approaching the bench. So we can skip ahead again.
Alright, so you know Mr. Melton's parents' address, is that correct?
Correct.
You know how to say the address. Ms. Baker's address was 160 Fun Drive.
Jesus.
Your Honor, I'm asking on the court to take judicial notice under CPA 4-2-201B.
Now, Mo,
Yes.
we can listen to this on your channel when you get there. Can we vote to skipping ahead a bit?
Yeah, that's fine with me. I
Yeah.
also don't
We-
want to
we-
get another broken eardrum.
And the sound is awful. Now, the sound isn't that good in this trial anyways, but unless there's a question from... Oh, they're standing up. Right. Oh no, they are just walking around.
Oh,
I would agree on that. You know, while detailing his day, Chris stated that Josh came to his house after he woke up on the morning of his day. Where Chris Melton? Well, let me change this. Chris Melton says that
Okay,
they went to
now we are
Grayson
live.
after 9:30,
We caught up.
and Josh McCourty says that they went to Grayson at 8 a.m. Yes, but from the Wachovia video and whatever else, we've got that stamp at 9:08. You're aware of the Wachovia video, is that right? Yes, sir. Okay, but our timeline is 7 a.m. to 9 a.m. 9:08 is outside of our timeline. We're saying 7 a.m. to 9 a.m. Josh and Chris are unaccounted for. Is that fair? Well, yes, if you want to say it that way, but to be in the Chick-fil-A is right next door to that also. To be in that area,
not the Chick-fil-A defense.
15 minutes from Fawn Road in Athens on morning rush on a Friday, it's going to be very difficult to do. My question again, why are we defending Chris Melton? Again, I'm defending what we were doing these first 3 days of this investigation. But Detective Bridges, you told us that Chris's parents' home is only 40 miles away from his neighbor's home. And you've already said that January 19, 2001 was 9,000 days ago. How do you know what the traffic was like, Detective Bridges? The route that we're going to their house, I drive a good bit, but I'll just say if you're going to do it in an hour, during that time frame, someone at Athens, Clark County, I'm not sure who did that drive, it's going to take you approximately that amount of time. Now, again, not defending Chris, I'm explaining to you how investigations in those early 72 hours are done when trying to line up those statements. Of course it does. I just want to make sure I understand your testimony. Your testimony is it takes an hour to get from Mr. Melton's parents' home to Miss Baker's home? Yes, for traffic.
Oh yeah, I remember. This was one of the most stupid things in this trial. While this witness was checking on Google, now this was that, if I remember correctly, this testimony was before lunch at that time. And at that time, then during traffic, it was an hour. But they were talking about 7 to 8 a.m. that morning. So
Yeah,
he's making
and
testimony. Yeah, it's an hour with traffic. Yeah, now, not 2001. And Logan's Athens, Georgia, has grown substantially since the past 20 years.
well, and for it being a weekend and a kind of rainy,
Or
cold weekend.
Friday morning it happened.
Well,
So it's still...
yeah, okay.
Yeah.
Yeah, I don't.
I'll check here, actually. It has grown from roughly 100,000 in the 2000 to 130,000 now. So it's 30% more people there now.
Yeah,
And
and
that has giant effects on traffic in that area,
yeah,
especially around the Walmart.
Well, and especially if there's back roads where you know there's not cops that you can go
Mm.
70, 80 mile an hour on it.
Mm.
I
Yeah,
if Chris
and we
was that
yeah,
familiar,
yeah, and we still only have Chris Melton and his friends' words of what they were doing between 7:15 and when they got to the bank right after 9 a.m.
yeah, you would think again when the state makes because I've only seen really the opening statement. So when the state says, admittedly, Chris was our first and most, suspected suspect, I would expect that you would have gone through everything he said with a fine-tooth comb,
Yeah,
not like freaking Spaceballs with the pick in the
yeah,
desert.
yeah. And one thing that was never entered into evidence, I don't think it was ever done. They never swabbed her injuries.
Could that have been because of the fire damage?
Could have. But still, what's the harm? Just swab it and send it for testing. Who knows? There might be, or there might not be. But if you don't swab it, you will never know.
I'm saying yes. Well, hold on. Let's be clear. So when I Google mapped it just a minute ago for you on the record, it said 1 hour and 4 minutes to do that 40 miles. So that was at 9:30, 10 o'clock in the morning past rush hour. So you would agree in 2001, Athens wasn't the city it is now, right?
Judge, I would ask, Zach Ricketts was in the middle of an answer, Bruce cut him off with this next question. I'd ask Detective Ricketts to be able to finish his response.
You're gonna allow him to finish his response?
Sure.
Is anything you wanted to add?
No, I was just going off the recollection of what I pulled up at 10:30 in the morning on Google right now. And yes, I'm sure traffic was different in 2001. Well, let's talk about this. It's 10:30.
So why even mention it? It's so
Yeah,
stupid.
and this is Cross.
Yeah.
Okay, yes, sir. Okay. And he could have been traveling, we don't know, at 6:45 a.m. Is that right? I don't know. But you do know, as you just told this jury, that at 10:30 on February 10th, 2025, 2026 is an hour before the drive. Yes, only because you asked me to look at that. That's the only reason I know that. That's irrelevant to our conversation about January 19th, 2001. Is that fair to say? Okay. Is that fair to say? Yes, sir. That'll be fine. Now, we have a discrepancy in the alibis, right? We have Josh saying Chick-fil-A. We have Mr. Melton not saying Chick-fil-A. Is that fair? Yes, sir. They're both saying that. One saying Chick-fil-A, one saying that. One saying what? One saying Chick-fil-A and one saying the Wachovia Bank. So you're saying the bank and Wachovia are next to each other? They're close there. So how do we explain Josh saying Chick-fil-A before 8 a.m. and Chris saying Chick-fil-A after 9 a.m.? Say that again? Sure. Your testimony was that the Wachovia is right next to the bank. Is that fair? Yes, they're close together. And you just made the statement that Josh said Chick-fil-A, Chris said bank. Is that fair? Yes. Okay. Josh said Chick-fil-A before 8 a.m. Is that correct? He did. Okay. Chris says bank after 9 a.m. Is that correct? Yes. So that's a discrepancy. Is that fair? Or both things could be true. They could have gone by that Chick-fil-A and then gone back to the bank. The bank doesn't open until 9. So my question is this: why are you defending Chris?
What?
Yeah, that is how they make excuses about Chris's alibi. Now, I can freaking guarantee you, if Chris Melton was on trial, they would have hammered this. It's not a real alibi, is it? Look at this. He said Chick-fil-A. You never said Chick-fil-A. You said bank, and it's an hour apart. And what? No, you have no alibi, don't you?
Well,
They would have
also,
hammered this as an unreliable alibi. But since they are trying to convict Mr. Faust, all of a sudden it's rock solid.
yeah, also could be that's what we would call again, if they were doing the read technique on Chris and he said,
Mm.
"Oh, no, I was at the Chick-fil-A." "Oh, well, about an hour ago you said you were at the bank, so which one?"
Yeah, exactly. And it's this discrepancy between his friends and his accounts of the entire day. But
Yeah.
since they already believe he's innocent, though those are innocent mistakes. They could both be true. No, they are inconsistent, you stupid fuck. No wonder you left the force and now started working at TSA.
I'm not. You're asking for information, and I'm trying to give it to you from the 72 hours that we were working the very first. Now, it is from the 19th, 20th, and 21st. Not even working this case. I believe we did 20 some odd. I did 20 some odd interviews during that time. Typically, this is what happens during those first 72 hours. Is you're trying to get timelines, and then over time, you start pulling those timelines together.
Do you know if Mr. Faust got that courtesy?
I don't work here anymore, so I don't.
But we can agree that Chris Melton got the courtesy.
I don't think Chris Melton got yours. I think we worked the case.
Oh,
Yeah. Now, Mr. Cruz is trying to, look at all the generosity you gave Chris Milton.
Yeah.
Why didn't you give that to Mr. Faust?
Yeah, I mean, if his, story didn't back it or get backed up, I mean, why wasn't a benefit of the doubt given?
Yeah. Because it's a black guy. And we all know if you have to choose between a white suspect and a black suspect in Athens, Georgia, you will step over everything to nail the black guy.
I mean, the DNA is damning, I'm not going to
Mm,
lie, just
yeah.
being a casual observer, but nothing else fits. And typically, when nothing else fits and you have an outlying thing, is it more likely that this is an anomaly or that this is, some fact pattern I'm not seeing yet?
Yeah. And you will get to this, but for my viewers also, according to Tara's best friend and roommate, there is a clear switch before New Year's 2000, 2001, and after. Before New Year's, she was always with Chris. After New Year's, they can't recall if they ever met her friends.
Yeah.
You only have Chris's word that they were together the weekend before.
Yeah, and, I guess my other thing would be if it was so completely racist at that time, you know, I haven't heard yet if she was the type of girl that maybe would have crossed that divide culturally and gone out with a gentleman because we can't hear, a black guy or Hispanic guy because we can't hear about her past. So,
But
that's another.
we know that Mr. Faust is not discriminatory. He had dated both. He was a player apparently back in the day, so not discriminatory. And when asked, everyone says, even Chris Milton says, she had not a racist bone in her body. We have never heard anybody say the same thing about Chris.
Yeah.
My theory is they probably broke up somewhere before New Year's. And he couldn't handle it. And then we also found out that he called her 5 times the night before her murder. And they haven't spoken, according to him, they haven't spoken that much for months.
He-
Is this a guy saying, please take me back, please take me back, go away, click. Calls again, and she eventually says, you know what? You're past tense. I already been with another guy. And that he could not handle.
Yeah, and if she knew that it would really bother him if it were an African American, my guess is if he pissed her off enough, she probably told him that.
Yeah. Yeah. And that's my theory based on what I've heard in this case.
Yeah, a lot of the decisions don't make sense to me. The covering with a fiery blanket, locking all the doors, wiping everything down.
Only taking the laptop.
Yeah, only taking the laptop. Again, I don't know what they were able to do in 2001 to retrieve certain things, but it does strike me that that's the only thing that was taken, and you would think at that time, I mean, 2001 wasn't the, dark
We,
ages.
but we didn't have cloud storage.
Fair point.
Yeah, this is before iPhones. It might even be before, well, iMac and stuff like that was, but a laptop was not that usual back then.
Yeah, I think we were in the moment of the BlackBerry.
Yeah, BlackBerry, and everybody was at MySpace.
Yes.
Yeah.
Except for me, because we had a family computer and my mom was afraid of social media.
Yeah, but yeah, now I know that Mo will make up her own mind if she hasn't already, based on the opening statements. But I mean, you still need to hear all the evidence.
What bothers me about the state's opening statement is I never want to hear from the state, everything is ordinary. Everything was ordinary. Everything checked out. Because the fact that you have to tell me, normally every story starts out with it was a normal day.
Yeah.
Because that cues you in that something's going to happen because it's never just an ordinary day. So
No.
I don't like that we didn't learn anything with the opening statement. I don't like that. I don't like that we were basically told, use your feelings, Luke. Don't look at facts. Don't you feel bad that this is a cold case and the family's been waiting? That's essentially what I heard.
Yeah, and already back in 2001, you could still do the phone dumps. You could still check the phone records. Now, this is 25 years later. Mr. Faust was never a suspect until his DNA was found. He can't get himself an alibi because people are dead, gone.
Yeah.
Phone records, gone.
Yeah, I mean, who keeps an ATM receipt? Would the bank even have a record of that? If he went to the ATM, if he went to a gas station or get a coffee or something.
Yeah, and the defense wanted to admit phone records, but the phone records they wanted to admit was from a company that no longer exists. All they could do is a computer-generated phone record, but they don't have anybody who can testify to it. So the judge wouldn't allow it in, despite her speech about this is a cold case and I'm going to treat it as a cold case, and implying that she would ease up on the burden of evidence. But she was very, very firm for the defense because they said, but this is a computer-generated phone record. When it is computer-generated, you don't need it authenticated by anyone. Only that it was computer-generated by someone who is a custodian of records somewhere else, but who was never an employee. But since it was no, not admitted.
Well, and it just also The infuriating part is that the state, just like Uvalde, is using this woman's horrible, tragic death, and instead of admitting, "You know what? We did a sucky job
Mm.
the first time. We are going to go back to basics. We are gonna go back and
Mm.
see what we can find, and hopefully we can get justice." Instead, they again, just from the opening statements, they found DNA. Oh, they found an excuse not to charge Chris Melton, and okay, we got it. We got a reason to do that. No, where was Mr. Faust during that time? What was he doing? Does he have a record for SA? I mean, it takes a lot to go from, okay, maybe my girlfriend lays hands on me or we get into some ruckus fights and some, hands are laid, to
Mm.
going to some random chick's house and, you know, hey, let's do some assaulting all the places and then let's, strangle her.
Mm.
That's a pretty big escalation in a little bit. And then to add fire to the mix.
Mm. Yeah. And to my knowledge, no, they never got Tara's emails. Maybe, or I have 4 sisters. I say this a lot of times. They keep track. If they write or text to someone or call someone, hey, I broke up with him. But somehow, because Chris Melton met Tara through her friends. So
Yeah.
this is a case where everybody knows Chris and Chris knows everybody in that house. Nobody wants to believe he did it.
Yeah, and you saw the same thing at the Canero trial. The first day of closings, his entire side was full. And
Mm.
then the state got through with half of their closing, and the next day, there was maybe 2 or 3 people on his
Mm.
side.
But we treaty, should we mention the FBI at this point, Nick? No, I want Mo to discover for herself.
Oh, Lord Jesus.
We just talked about this. You said that you explained that the reason Josh said Chick-fil-A and Chris said the bank, you said 2 things to be true at once. You're saying they could have went, this is your testimony, they went to, I guess, to Chick-fil-A by the bank first, and then after 9 a.m. went back to the bank. That was your testimony, is that right? Yeah, when we're looking at this during this time frame, so when you take somebody who's been involved with crime or whatever else, and they've been a victim of crime, they're giving witness statements. Things are recalled the next day or so. He forgot what code here, which is a timestamp thing. Don't know why I forgot that until Sunday. Don't know. Normal people, through the course of doing investigation for almost 35 years, do not walk through and timestamp their day. They can give you approximates and say this and that. The majority of the people I've interviewed for homicides, whatever else, and not saying a bank house at 908, whatever else. Now, I understand what you're saying. This was a timeline of 3 days where we're trying to put people where they're supposed to be. And I'm testifying to those 3 days when I get on those. And some of it, like I told you, I didn't do those interviews, so I cannot answer that for you. But we're trying to put people on those spots and then see what evidence moves from there.
You would agree that Ms. Baker is the victim in this case?
100%.
Since January 19, 2001, Ms. Baker was the victim, is that correct?
100%.
And her family were victims, is that correct?
100%.
And ACCPD's job as law enforcement officers are to make sure the victims are taken care of. Is that
One of the fire marshals smelled her hair and smelled shampoo, according to him.
Answer those questions, is that right?
Yes, sir.
What in the serial killer? Who the hell goes to a fire scene with a dead body and thinks, you know what, I'm gonna sniff her hair?
Yeah, but that is how the prosecution claims that this happened after she showered in the morning. So it had to have been between she normally woke up and when she went to class.
Okay, I call bullshit, because if you're ever around a bonfire or even a nightclub and you're in there, you come home, your hair smells like smoke, either nicotine or wood smoke. So she couldn't have been in a fire and then her hair still smells like coconut suave. I cannot with this.
Now, there might be some product somewhere, anywhere, that when exposed to heat makes some kind of weird scent, but it's still no. I don't know what that fire person was on that day, or why he recalled that. I have no idea. But it made the prosecution claim, well, it must have happened after because she showered every morning.
Here is Dingus, though he's not impressed. He's also 40 pounds, so fighting him is like, would you stop
Well-
with the keyboard?
Mr. Jingles is a lightweight compared. He's only like 25 pounds or something. 20
Well, I might be
maybe.
exaggerating about the 40, but he's huge.
Yeah, we could see that.
I'm explaining away 72 hours. I'm not
And how the fuck are we 15 minutes behind all of a sudden?
I'm sorry. I took it as you were implying, but no, it's not. I agree with you.
Let's check ahead.
January 20th, 2001, you spoke with Mr. Bill Tier, is that correct?
Yes, sir. We're fine.
And Bill Tier?
Yeah.
On there,
Okay.
there are neck scratches, things of that nature, but that's what I mean by abrasions, just that larger.
Correct. Did you confirm with anyone else?
Again, you're going to watch this entire testimony at
I
most,
didn't know, but I believe somebody talked to his roommate and we're the
so we might as
Will
well
Mo be
skip a few things.
sober? Probably not.
The only person that would have been in the house is just the two of them.
So you don't know if they're talking about this.
No, I'm saying somebody else did, but I did not talk to that roommate.
It's weird that they play the objections and the sustainments and everything, because that's not evidence.
And on January 23rd and 24th,
Yeah.
They asked for his testimony.
Yeah, but I don't know that they
Yeah.
have time to crop it out.
Yeah.
taking hair sample from Chris Newman, is that correct?
Yes, sir. I believe that's correct.
And this was known to Detective Newman.
Yes, sir.
Do you recall requesting and obtaining a court order for phone number 678-725-4136?
I believe that was the 24th that I did the hair samples. Is that correct? I said yes, but I want to make sure I'm on the same page with
This
this.
is correct, that 23rd.
Okay, the 24th, I have the 23rd, 24th written in there, but I just want to make sure that's the date you're talking about. Is that the report you're looking at?
No, sir.
Okay. Yes, sir, we did do hair samples on these days.
And you also obtained a court order for phone number 678-725-4136, is that correct?
I signed for it, and yes, sir, I did. I don't have a signed copy of that with me. Yes, sir.
They are not allowed, the defense, to even mention it might have been consensual, because that would imply talking about her sexual history, which is banned through the Georgia Rape Shield Act. So they were not allowed to talk about that she might have been seen at a bar the night before or 2 nights before, a bar that Mr. Faust was known to frequent.
Huh.
Your Honor, after this, can we take a break?
Well, the jury never heard that.
Can you just let you
All we know is, and here's the thing, they never actually tested this trace DNA that didn't show up in 2001, but in 2024, they didn't test it for sperm. All they know that it is DNA. Now, remember, both swabs were labeled mouth swabs. And then they claimed mislabeling. sent it off
Mhm.
to a California lab, who then did a presumptive test that said it might be vaginal. But the test only have a presumptive test. There is no way to test that further for a confirmatory test. So all they know is that they have two mouth swabs where one looks a bit different from the other. And the claim is, since it's presumptive, and here's something I will argue until kingdom come. If it is presumptive, it doesn't come in as evidence because it's just presumptive. So all we actually know, according to the evidence, is that Mr. Faust DNA was found on the swabs that was labeled mouth. Now, this is trace DNA. Do you know, and it is a small amount, that it wasn't rediscovered for 20 years because the technology got there. There are a few cases. No, we actually don't know that. They were labeled as mouth swabs. Now, you can logically come to that conclusion because it was from a grape kit where they tested the back door, the front door, and the mouth. Sure, it could have been mislabeled. Mr. Jingles, your claws really hurt. Oh, I have scratches on my shoulders that from time to time get infected. This is not fun. I love this guy, but damn, at the seventh time, it gets annoying.
Yes.
Hmm.
We need to get him some very strong catnip and then clip his or file his nails. I don't know how.
Yeah, but my argument is presumptive tests that could or could not be. It has indications of vagine things, but it's still just presumptive, and that should never go to the jury. Never. Ow. And now you're biting my finger.
I saw that. I was like, oh, Mr. Jingles is reasserting his dominance.
Yeah.
I see you trying to stop me from booping you. I see your.
Yeah. And here's the thing. I do this because he at least stops booping for a while. But then he only learns, oh, if I do this, eventually he will pet me.
We need to make you some chainmail armor just for one shoulder.
Just one shoulder. Yeah. Where was it? Yeah, the presumptive test should never be allowed as evidence. And even and when it comes, they actually never have, as I said earlier, they never tested, is it sperm? They never actually tested it. And still, the prosecution was allowed on their PowerPoint slide to label it as sperm. It was not in evidence. It was never in evidence that it was sperm because they never tested it for sperm. So what we do have is trace DNA, provably in her mouth. Folks, do you know how easy it is to transfer DNA? He could have grabbed the bowl of peanuts, and then she directly after grabbed the same bowl of peanuts and ate. That would have been enough to transfer tiniest amounts of DNA.
Yeah.
cases out there where somebody's DNA was found at a crime scene, convicted, but then through evidence and missing video showing up later, no, that guy was not even there. His alibi did check out.
Yeah,
And
that's the problem,
that
I
at some
think, with
they were at the same place. Don't know exactly how the exchange happened, but somehow his transfer DNA got transferred from him to there. And it all. Hey, if I do this hatu on the microphone, and then Mo touches the microphone, and then go touch something else, that DNA here gets over there. That
yeah,
transfer DNA.
yeah. I think the problem is that in our minds, we're still in the DNA of the mid-aughts and probably 2010s, where we would get a lot of single source profiles. So, oh, we found this person's DNA. The general population hasn't moved forward to this because DNA is so sensitive now that most everything is a mixture of,
Yeah.
3 or
You have
4 or more
you
people.
have a
And
majority and minority DNA, stuff like that. And then with all of this, where Mr. Faust and Mr. Because both their DNAs was in the mouth, there were more, but too small to be identifiable.
yeah, and that's where I think that defense attorneys, not that the burden should be on them, but they're going to have to work a lot harder
Yeah.
now with this trace DNA. Yes, I understand my client's DNA is there, but this is how the process works. They multiply it billions and billions of times.
Yeah.
So
The
it
the
might have been
ori-
a single,
Yeah.
skin cell that was there, but because they made a gajillion and 12 replicas of those areas that they test, yes, my client's DNA is there, but he was there at Kroger.
They drank from the same bottle of beer.
Yeah.
That's enough. And transfer DNA, the easiest way to explain transfer DNA, do you know what that is? Well, the swab. They swab there, and they put it over there on the glass looky thingy. That's how easy DNA is transferred. Yeah, you're all Scandinavian.
True.
And Treaty on your channel, Mr. Jingles renamed the channel to Claw and Crime.
Yes. Well, considering law and crime is buying everything up.
Yeah. I think that is too close to them. They will file something against me.
Yeah, probably.
Well, maybe I can. I will ask Kathy. Or we are so far. No, we're getting so far behind again.
Calls it, but Detective Ricketts was in the process of explaining what he would have done if it were some kind of thick coating that Mr. Cruz stopped him in his answer.
I'm going outside.
All right, so Detective Ricketts, I'm going to kind of ask you that question again. During cross-examination, Mr. Cruz stopped you in the middle of your answer as you were discussing what you would have done had you found a thick coating of things on Mr. Melton's hands. Can you explain to the jury what you would have done if you had seen that?
Well, number one, if it's a large amount, you can't be fingerprinted. So that would have interfered with just the fingerprinting if there was a large amount. Now, on the back of the hands or whatever else, there wasn't enough stuff on his hands to cover up anything that might have been there.
And you remember that
So if there would have been things that would have
25
had to
years
be fingers
later,
in it,
despite not mentioning it
had
in
to
your
be
report?
determined some other,
Interesting.
ways that we'd have gone on from that moment on. But those were not noticed. And
We are
again,
actually back on actual live now.
holding his hand while
We're
fingerprinting.
skipping ahead.
I mean, my hands are holding finger by finger as I flip that hand over. I'm having to hold his hand.
Also, during your testimony, after the distance from 160 Farm Drive to Mr. Melton's parents' residence was established, you testified to a timing run that was done by ACCPD at the time. Is that correct?
Yes, sir.
And I just want to clarify that because I feel like it might have gotten lost in your testimony and questions coming in while you were talking.
Objection, Your Honor. This calls for hearsay. Yes, we explicitly did not ask him about the times. Yeah, we disagree with the times he goes in. But the reason we didn't ask this is because we know under the law that it's hearsay.
Right, any response to the objection?
Well, Judge, this is a response that was given to Mr. Cruz's question about what was done. The response is about what ACCPD did at the time. And the answer was given during Mr. Cruz's cross-examination. I'm just going back to talk about that answer. That answer wasn't objected to or asked to be struck or otherwise identified as hearsay by Mr. Cruz at the time. So it's in evidence, and I think it's an appropriate grounds for redirect examination.
Yes, sir.
I was just asking, Your Honor, I'll leave to the discretion of the oath board, but if that door is open, the reason I didn't go down the impeachment route with that line of questioning is because I wanted to follow the law. That is inappropriate to withdraw. Bring out the witness. That was not responsive to my question. But if the state is allowed to go down that line of questioning, I would just ask the court allow us to follow up with that line as well.
Okay, thank you, sir. The objection was with regard to hearsay. I don't find that this question is going to elicit hearsay. I'm going to allow you to ask it. Certainly on any recross, we will address any issue that the state might object to, and we'll take it up again if we need to, but you can go ahead.
All right, and so Detective Ricketts, what was it that you stated was the time period when ACCPD or law enforcement did a test run back in 2001?
It was over an hour with traffic. So it took them just a little bit over an hour to make that drive.
Okay.
Did they obey by all the traffic laws? Did they take the route that
Yeah.
took the longest? Did they try any side routes? Did they step on it?
Yeah, there's so
It's-
many variables.
Yeah, it's so stupid.
Were the traffic lights even the same? Have there been more traffic lights added? Were there more intersections added?
I wanted to talk to you just really briefly about your familiarity with some of these areas in Loganville, Grayson, Trump Customs. During your testimony, you made reference to the fact that you drive that route at least semi-frequently. I'm not asking you an address where you live, but in general terms, what area of the state of Georgia do you live in?
Toward Gwinnett County, that way off 78.
Are you familiar with these areas that we've been discussing, kind of independent of your investigation?
Objection. Gwinnett County's evidence is irrelevant to any facts that are already in evidence.
Right? There's a relevance objection, Mr. Youngman.
So is the objection to the follow-up question that I asked, or the answer that Mr. Ricketts gave to the previous question? I'm just not sure.
To the follow-up question, Your Honor.
Right? do you want to respond?
Yes, I do, Judge. The follow-up question was, are you familiar with the areas that we've been discussing as it relates to Loganville, Truck Customs, Grayson? So I think that is relevant.
Okay, is that your objection, Mr.
That was
Cruz?
not the follow-up question, Your Honor. The follow-up, he asked us about Gwinnett County to these areas, to these parts around here. That is not relevant. Mr. Melton stayed in Loganville, which is outside of Gwinnett County. So Gwinnett County to Athens is irrelevant in this case.
Okay, let me just say this. I think you're referring to the question before the follow-up question, but we can talk about that. I think that is your objection.
Yes, ma'am.
All right, and so that question has already been asked and answered, but let's let the state, if they choose to respond to the objection about relevance when you asked about the Gwinnett County area. Do you care to respond?
Yes, Judge. I think Detective Ricketts during cross-examination indicated he was familiar with that general route. And now I'm going back to establish why it is that Detective Ricketts is familiar with that general route. And then, obviously, court heard the follow-up question, which had nothing to do with Gwinnett County. It had to do with his familiarity with these specific areas that we've been discussing.
I'm going to overrule the objections.
So, Detective Ricketts, I'll go back on our second question again. So, as it relates to the discussions we've had about Loganville, Truck Customs, and Grayson, are you familiar with those areas?
Yes, sir. It's like a small triangle that we're there together. Loganville, Grayson, all those little areas are very close to each other, like in a triangle.
And so when you say very close, let's just talk about Loganville and Grayson. How close are we talking about?
5 miles or so. I mean, they almost touch each other, I would say.
Okay. Repeatedly during cross-examination, Mr. Cruz made reference to you being unable to obtain documents from Nash Plumbing and some of these other locations that both Mr. Melton and Mr. McCurdy said that they both went to. I just want to clarify, because I think sometimes unable can lead to a certain impression. Did you ever actually even attempt to do that?
I did not.
Okay. So is it fair to say that you didn't ask and then someone wasn't able to produce them? It's just that you yourself never asked.
That's correct.
Also want to talk a little bit about differences in timelines. And obviously, Mr. Cruz had Mr. Hill write some things on the flip chart. I don't need a flip chart. Detective Ricketts, in your having received all that information from Mr. Melton, Mr. McCurdy, and Mr. Teeter about Mr. Melton and Mr. McCurdy's whereabouts on January 19th of 2001, was there anything that you received from those individuals that caused you concern about the integrity of those statements regarding where they were?
No, similar to the whiteboard, we use a similar thing, simply go across. And on any kind of investigation, which started back when I did those and even to this day, we would go across with a timeline, and you get the second subject, and you go across with a timeline, and you get the third, and the fourth, and the fifth, and you start looking for consistencies and inconsistencies in those timelines. In this first 72 hours, just because Chris came back and remembered the bank, again, like I said when Mr. Cruz was talking to me, that's not abnormal for the timelines not to be minute by minute, to be some overlap. On that first 72 hours, we weren't concerned about that overlap. We weren't concerned about any of that. We wanted to move on toward getting fingerprints, DNA, and push the investigation that way. So we were trying to secure all that. But that timeline didn't give me any pause at the beginning. Now, we've had investigations before, just to give you a this or that. Investigations where as soon as you put the timelines on, you're like, they're in another world. So when they're close together and you can put that line close together on a board, you can kind of work that out. And I wasn't, in that first 72 hours, I was not at all uncomfortable in what we were doing.
And so, as far as these variations that you saw that we've talked about between Mr. Melton, Mr. McCurdy, and Mr. Teeter, would those be consistent with variations that you had experienced in other investigations that you had?
Yeah. They spent
Was there anything
7 out of 9
unusual
days
to you
defended
about
defending
those
Chris, and
things
then
not
2
being
days
minute for
trying
minute exactly
to
the
pin
same?
it on
In the
Mr.
first
Faust.
72 hours
Y-
plus,
It's
no.
the same problem Karen Reed's. It
Mm.
it's the same problem Karen Reed's trial had, because to an outside observer who didn't watch, all the backstory and came in, I remember asking Baker and Valhalla, I was like, "Who are these people? And wasn't there a dead guy?"
Yeah.
Because like the first week was just all these people. No, I had a phone charger and I looked out the window and I thought that Valhalla and Baker were punking me. I was like, this is not a murder trial.
Yeah. Yeah. The amount of but dials, but talks, but hanging up. I mean, folks, an iPhone, when it locks, I mean, did you have facial recognition on it and it opened with your asshole?
Yeah,
That's a problem.
that's the other thing. Things should make sense. In the real world, things generally make sense. They do. I mean, now in the real world, things happen that you couldn't even write for Hollywood, though. No one would believe you. So it just none of this makes sense. It should make a logical thought pattern. You shouldn't have to think about it too hard and ignore a bunch of things that don't fit. When either side is asking you to ignore something that doesn't fit, it's a warning sign. It's not a good thing, at least in my opinion.
Nothing was out of that.
It is absolutely relevant, even independent of Mr. Cruz's questions on cross-examination, but certainly at the point that the information is solicited on cross-examination, it would be relevant in a redirect. Improperly refreshing the witness's recollection, what the law says about that is that a witness's recollection can be refreshed with anything, including things that might not make sense. I could hand him a pack of exhibit stickers and ask him if it refreshes his recollection, and it may or may not. So I don't think that that's a valid legal objection in this circumstance.
Well,
Yes, sir.
I have know what you're saying. Know what you're saying. It's report from one person that he's going to show.
Oh yeah, this is the 3 times hearsay they want to get in, because the witness they are referring to is deceased. The cop who interviewed and wrote the report is also deceased. So they are now trying to get in the witness statement via a report. That is, reports are never evidence in itself. And they are trying
No.
to get it in through this guy.
No. What in the name of all that's giblets is going on here?
Just refresh his recollection as to what the third person said. So I add that objection.
Well, and Your Honor, if I may respond to the new objection. So once Mr. Cruz solicits that information on cross-examination, I believe he's barred from raising an objection during the redirect examination as to that same information.
Yes, one more time, yes, sir.
I know Your Honor knows the law. I'll just leave it there.
Okay, thank you, Mr. Cruz. All right, with regard to the relevance, I certainly find that this is relevant based upon both examinations this court has heard with regard to this witness. I'm going to overrule the relevance objection with regard to the refreshing recollection. You are entitled to refresh this witness's recollection if it does. So you may refresh his recollection with
Some time ago, during cross-examination, the defense wanted information in through his blah 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 of recollection. Now the states, they were denied. Now the states wants it in via different channels.
Yeah.
So they test this way, and this way. And the judge does her analysis, which she didn't do on opening statements when they, hey, we know that, but we are going to get it into it via this and see, no, you're just trying to circumvent. And she fined him $1,000. Here comes the state asking the
Yeah.
judge to try different theories. Sure, I'll allow it.
Yeah, that's some bull poop right there.
anything, we're going to take it from there, and then I'll make a ruling on the hearsay. So you may go ahead with your refreshing recollection if you can.
Thank you, Judge. I'm going to show Mr. Cruz a copy
He's asked to be thus looking at a report somebody else wrote 25 years ago about a witness you never saw. How does anything he didn't actually witness recollect him of anything? Because the report in itself is not evidence.
Well, not only that, but if he wasn't the person that was even talking to the other person, how does he know the inflections, the body movements, any of the other things that we use to communicate?
police report from May 4th of 2001.
I am going to object. I don't understand how another detective's police report refreshes with his recollection. The foundation hasn't even been like, he never asked a question. Do you remember Rebecca Taft's report, May 4th, 2001? He hasn't laid the foundation of this officer even read this report.
All right, thank you. All right, and any response to that objection before I make a ruling?
No, Your Honor.
All right. The law is that if a witness does not recall, the state can ask, or the defense, any party can ask to refresh a recollection. It doesn't mean that the witness's recollection is going to be refreshed today.
But he's asking to be recollected about what somebody said to somebody who then wrote a summary of it in a report.
Yeah, that doesn't. Why am. This can't be legal.
Welcome to Judge Slott's court.
Any party is entitled to use a document, an object, an audio recording, a visual recording, anything can be used to attempt to refresh the witness's recollections. I'm going to allow the state to attempt to refresh a recollection, and we're going to take it from there. So open with objection, allow you to continue, and then we'll take it from there. I'll rule then, if necessary, on the other part of this process.
Thank you, Your Honor. Detective Ricketts, I'm going to hand you this, and for the record, it is a police report from
Let's go up to. Oh,
Ooh.
Play the whole thing.
Mr. Chris Melton's father.
Yes, I knew a detective had gone and interviewed them both. I just couldn't remember if it was her or John or Painter. Not Painter, but anyway, I knew it was one of the ones. But yes, this is the recollection of the report that I remember seeing.
Okay, all right. So I'll come get that back from
All right, and at this point, since the recollection has been refreshed, I'll send the jury up for just a moment to take something up outside your presence. Please don't discuss the case.
yeah, now it is 5 p.m. in Georgia. So I'm guessing that is why the judge interfered here or something.
Yeah.
Of you, okay, I'm going to ask the foreperson, or I'm going to ask the jury. Let me just ask all of you. I got a message that you are done listening to the tape. Is that a consensus, or do we need to play the whole thing? We certainly can do that. Which one? That we're all done? Is that correct? Okay. All right. Thank you. All right, ladies and
Oh, so they interrupted it in the middle of the state's redirect.
they
I
were
would-
like, God.
Yeah, I would generously I would interpret that as positive for the defense.
Yeah.
gentlemen, we are going to show you the documents that you have asked for. And counsel, if you can make sure that the group that we talked about is what you want to submit. Is that it also? Or is that something different? Okay. I'm going to pass it around. And what we're going to do is start in the front row and have you all look at them and just pass them along because they need to be viewed in open court. And if you change your mind, everyone, and you need to hear the rest of that tape, just let me know and we will do that.
No.
No, God, no, please don't. I mean,
Well,
jury, it's up to you.
you're still going to listen to it, but in 1.25 and with good audio, or decent audio at least.
Yes.
And you get to see the cop as he testifies.
Yeah. None of this is adding up to make me comfortable with any of this.
No. Okay, so now they are. Well,
Go back with you again to the jury room, but you can look at them as long as you need to here in the courtroom. I also want to tell you this. I'm going to give you a cautionary instruction. And this is based on the fact that you have reheard some testimony in this case. The cautionary instruction is this. Please remember that it is important to consider the whole of the evidence that has been presented in this case and to refrain from giving greater emphasis to any evidence you may have heard twice. Thank you. Mr. Otero, if you will start with all of these exhibits, and I think we just start in the front row and take your time, and you all let me know when you're finished. And everyone.
they already have made greater emphasis by asking for this. What? I thought she would say, remember that when you heard me overruled, that means you can't take that into account.
Yeah, I
That
thought that's what
lawyers'
she would.
questions is not evidence; it is the answers that is. No, she just says, "Oh, remember, don't take too much into account just because you heard it twice."
Yeah,
That's why they wanted to hear it, bitch.
Yeah, I mean, there was a reason that they wanted to hear it and see it again or
Yeah.
listen to it again. There's obviously something that all of them agreed, or a majority of them agreed they needed to hear again.
Yeah. And they came in with this question just, I mean, was it an hour and a half after they started deliberating? I mean,
Yeah.
that's quite significant. It's almost as if they are going through, okay, but this, yeah, but I don't remember it that way. Okay, let's listen to it again. Or it's
Yeah.
already just one holdout or two holdouts that says, no, this is what the evidence was. And the other was, and then 10 others says, no, let's see if we can listen to it.
Be at ease until we are notified that the jury is finished. Thank you.
And we're up to, I mean, now they are just going to look at this, and then I assume they are going to go back to either the jury room or home. I mean, it's 5 p.m.
Yeah. Well, did they say on Friday how late she would allow them to stay in the evening or anything like that?
She gave them the choice to either start deliberating now or Monday at 12:30, and they say, well, we want to start now. And then they came back just a half hour, 45 minutes later, probably only choosing the foreperson. And then they had a long weekend. I don't remember her saying you can stay as long as you want. So, do you want to go back and listen to your stuff?
Okie dokie. Let's.
While we wait for anything else to happen.
Well, what I'm probably going to do is, it is 5 p.m. my time. I am
It's a,
probably going to call it a day for
yeah,
me here.
it's
And
11
then,
it's 11 p.m. my time. Folks, there's not going to be a verdict anytime soon. Now, I'm going to keep listening in just in case, and then I will start. If anything happens, I will
yes.
start a new stream, and I will shoot off a link to Mo. If that,
Yes.
but if she will go on or not, that's a whole other question. But
I don't anticipate, if they do have a holdout, I don't anticipate someone not saying, hey, let me sleep on it tonight. Let's come back
yeah,
in the morning,
mm,
because this was some dense testimony
yeah,
that we were listening to. And if it's something they're really fighting about, it might be something that they say, okay, we're not getting anywhere. Let's go home for the night.
yeah, yeah. I actually agree with that. That is more probable. So yeah.
Yes. So thank you for everyone who's hanging out with Nick and I as we do a speed run for my first time through this trial, Nick's second
Mm.
time through this trial, and we simultaneously do verdict watch. So we might get sidetracked during our speed run, but it's kind of interesting to have this outside perspective when so many people already know different
Mm.
things. So it
Yeah.
is interesting to kind of, and I don't mind it when you guys spoil things, because I'm like, wait a minute, this doesn't make sense. Are we going to learn something? And you're like, no.
Yeah. And once you get to these parts, you're going to say, oh,
Oh,
that's
that
why.
makes
And it's probably going to be worse than we explained to you.
Yes. I have
Mm.
found that to be the case. So thank you so much.
Mm.
If you're on my channel and you haven't already, please go over and subscribe to Nick. And
Same right back. If you're on my channel, go over to Mo and subscribe to her.
we will be back I will probably start at 10 again tomorrow. That's just my normal time to start. I don't know if she's also going to have them come in later.
Mm.
So if I see that they're going to start much earlier, I might put it at 9, but I
Yeah,
generally just start at 10.
I can never say when I'm back, when I'm home from work. I mean, the
I
last few
completely
weeks have been
understand it.
absolutely insane. But if I'm home, I will join. And if something
Sounds good.
happens, they have a new jury question or even a verdict, then I'm going to start my stream, my verdict watch stream. Because I want
Sounds
you all
good.
to go and listen and subscribe and everything to Mo as much as humanly possible.
Yes, we have to beat Laura Owens by the end of the year, and her
Yeah.
mom.
And her mom. Yeah.
I just
Laura, that's not a physical threat.
no.
No, we are
No.
meaning, since you got 83,000 from your podcast, me and Mo together this year should have at least 41,500. But
Yes.
that's up to you. That's actually up to you guys. So watch everything we have ever produced. If you have the means, if you are one of these persons who have 3 lattes from Starbucks, give us one of them.
Yes, at least for my husband's sanity, because I'm trying to find, so not that that is in any way related, but I'm trying to find, since I'm doing more police reaction video, as a police costume
Mm.
that isn't, you know, also a streetwalker costume. So I it's it's honestly not the easiest thing to find. When I'm on trial and my my history is pulled up and they're like, "Why do you have cop costume not sexy written down?" And so
Reminds me of the Halloween a few years ago when me and Dave, we dressed up as cops and watched the Jodi Arias trial.
Oh, I remember that.
Yeah.
Well, thank you guys so much for
Mm.
hanging out with us. If you
Thank you.
guys want someplace to hang out before the trial tomorrow, the speed run, then I do mornings with Mo. I do headlines, true crime, and the absurd. I skip the politics. I don't give you my hot takes. I don't tell you what to think. I just ask you to think. And my algorithm is crazy. So when
Mm.
I say I find weird stuff, I find weird stuff, but it's
Yeah.
awesome.
Yeah.
So
Oh,
I will
okay.
see you guys. It looks like my internet's crapping out too. So saved by
Yep.
the. So I will see you guys later. Bye, you guys.
See ya. Bye bye.